All persons having business with the appellate division drawn near, in attendance, and shall be heard. Please be seated.
Wow, it's like a packed courtroom. What's going on? Who sent out the invitations? I did not. Good afternoon, everyone. Welcome to the Appellate Division First Department. Our arguments for today, September 26th. So all of you know the spiel in terms of the requested argument time. This sheet says that there's 8 hours requested argument time. So obviously we cannot stay here for 8 hours. I mean, we could, but we're not. So please keep in mind, just ask for the time that you actually need to argue. We have read your briefs. We are fully familiar with your arguments. People v. Edwin, Burgos.
Good afternoon. Appellant, request 6 and 2, please. Respondent, request 6.
5, 2, and 5. Mezanavi versus Tasha, bikova.
Present.
I think we only have the appellant. Mr. Mezanavi, you're on screen. How much time did you need, sir?
8 minutes for argument and 2 minutes for rebuttal.
I don't know if there's anything to rebut because I don't think that a respondent is present. So we'll give you 5 minutes then, sir. Marlene versus, and by the way, that case is going to be called first, okay? Marlene H versus Lauren D.
Yes, Your Honor. Good afternoon. I think 8 minutes.
And you are the,
Sorry for responding.
for you don't have an appellant, so you, okay. 2 minutes then, thank you. Alberico versus LDG Builders.
Appellant, request 4 and 3. Respondent, 3 minutes.
433. Chopra versus Kiku Japanese Barbecue.
Good afternoon, Your Honor. Appellant, request 4 and 2. Respondent, request 4.
424. People versus Jermaine Hampton. That matter is submitted. People versus Vladimir Kroll.
Good afternoon. Appellant request 6 minutes and 1 rebuttal.
Respondent, request 5, Your Honor.
515. Dobkin versus Hub International.
Good afternoon, Your Honor. Appellant, request 4 and 2. Respondent, request 5.
424. Shane versus Rosenwax.
Good afternoon, Your Honor. The appellant requests 13 and 2 for rebuttal, please.
13 what?
13 minutes.
Do we have a respondent?
Good afternoon. I don't think we need more than 5 minutes.
Yeah, I do agree. 5, 2, and 5. Valente versus MTA.
Appellant Mendoza, 4 and 1, Your Honor.
Appellant Lawrence, 6 and 2, Your Honor.
Appellant Charles and the estates of Nancy and Darrell Douglas, be rest in brief.
Okay.
Respondent MTA entities, 3 minutes.
So we have 4-1, 4-1, submission, and MTA, I'm sorry, how much time did you request?
3 minutes.
3 minutes.
I'm sorry, Your Honor.
And who are you?
Appellants, building materials and James Smith. 5 and 1, please.
Okay, so you're 3 and 1. So we have 4 and 1, 4 and 1, submission, 3 for MTA, 3 and 1 for you. People versus, I'm sorry, that was MTA. Matter of Carmen,
Appellant 5 and 2, please.
ACS, 5 minutes.
424. People versus Alberico Torres. That matter is submitted. New Wealth versus 33072 Owners Corporation.
Appellant, Your Honor, 5 and 2.
Respondents, Your Honor, respondent, I should say 5 minutes.
525. Wong versus Wong. Justice Gesmer is recused on that matter. What's the whispering? I can't hear you. If you're gonna talk, don't whisper because I got to be able to hear what you're saying. Okay? No whispering. 5-2 and 5. 5 Star Electric versus Silverite Construction.
Appellant, 6 minutes and 2 on rebuttal.
Respondent, 4 minutes.
524. People versus Collins Williams. That matter is submitted. Lowman versus Consolidated Edison.
Good afternoon, plaintiff appellant request 5 and 2.
I'm sorry, who are you?
Plaintiff appellant 5 and 2.
Thank you.
Respondent Clayton, 5 minutes, Your Honor.
Good afternoon, Your Honor. Appellant respondent Nelson requests 5 and 2.
You're Nelson. Okay, 5, 2, 5, and 5. Justice Gesmer is recused on that matter. People versus Jesus Ayala.
Appellate request 4 and 1.
Respondent request 4, please.
414. People versus Silvestri Rosas.
Good afternoon. Appellate request 4 and 1.
Respondent, Your Honor, 2 minutes, please.
412. People versus William Mitchell. I'm sorry, William McNeil.
Appellate request 4 and 1. Your Honor. Respondent request 3, Your Honor.
413. Tasha Bava versus Family Home Care. That matter is submitted. By the way, Justice Oing is recused on that matter. Burns versus the City of New York. That matter is submitted. As I said, the first case for argument will be Mezanavi versus Tasha Bikova. And Mr. Mezanavi, you have 5 minutes. Whenever you are
Thank
ready,
you,
sir.
Thank you, Your Honor, and thank you for the remote session. I am denied the use of my passport, so I appreciate the accommodation. I have 4 points to make. Can you hear me all right?
Yes. Thank you. You may proceed.
Your Honors, it brings me no pleasure to be bringing up inconvenient truths, but if we have any chance at the rule of law, we have to begin with the truth. Even when they're done under the color of law, family separations without due process have always been atrocities. There were atrocities 70 years ago when the states were doing it to Indian children. There were atrocities 7 years ago when the Trump administration was doing it at the border. And family separation is an atrocity in this case without a hearing, without representation, without basis, and without an initial custody determination. Sister Janaya and Brother Yasin need to be in each other's lives. Both motion sequence 9 and motion sequence 10 aim to remove the many barriers that were placed between the siblings. Point number 2, when your spouse asks you for divorce, maybe you suggest counseling to prioritize the child, if not save the marriage. You don't false report your co-parent for retroactive child abuse the very next day you're asked for divorce. You don't subject the vagina of your 1-year-old baby to repeated colposcopies and biopsies to try to paint your co-parent as an abuser. You don't frequent the ER to try to manufacture medical issues where there are none. You don't falsify school applications to prevent teachers from getting hold of your co-parent. You don't denigrate your co-parent in front of the child's classmates, teachers, doctors, neighbors. Nor do you present yourself as a persecuted lesbian since age 4 in one court, and in the court across the street try to extract millions from a heterosexual spouse whom you've conned into marriage. Nor do you defy deportation orders or access orders. When you need a driver's license, you learn to drive and go to the DMV. You don't forge your own driver's license. When you need more money, you work more and you spend less. You don't cheat on your taxes and get paid in cash. You do these things, Your Honors, when you put self above the rule of law and above the interest of your community, including the interest of your own child. That is what Ms. Tasha has done, and that is the conduct the lower court was willfully blind to. Point number 3, 2 wrongs does not a right make. They make a fight. 3 wrongs does not a right make. They make a longer fight. The lower court piled procedural wrongs on top of substantive wrongs. As a result, Your Honors, we simply do not have the antecedents of a legitimate decision, let alone a provident one, because the lower court did not consider salient factors such as the crimes and child weaponization committed by Janaya's current caregivers. Crimes and child weaponizations are not consistent with parental fitness, let alone with sole custody of a child. The lower court not only did not digest easily ascertainable facts, the lower court suppressed evidence of crimes and became an advocate instead of a trier of fact. That, Your Honor, is both intrinsic and extrinsic. And my, hello?
Yes, you can continue.
He's frozen.
Or not.
He's frozen.
You froze.
Hello?
Yes, continue.
That is fraud, both intrinsic and extrinsic. And pages 8 through 13 of my reply brief details the extrinsic portion of that fraud. As a result, we have an indefinite sibling separation and the effective termination of family rights without basis. Point number 4. Every summer, Janaya used to come and see her paternal relatives here in Plovdiv, even when I was living in New York. Now that I live here and Janaya has a sibling here, she has more reasons to visit, not fewer. Every summer, I see American families bring their kids to Plovdiv to study the ancient world because this is the oldest European city. 99% of these kids have no relatives here. In contrast, Janaya has half her family here, including a sibling. Moreover, this country is a signatory to the Hague Convention. Not only that, it's a compliant signatory. The lower court approached the matter with prejudice, and that prejudice has allowed Mr. Shibikova to hold Janaya hostage so that the siblings are not completely cut off in perpetuity. Janaya needs to be spending a portion of her summers here to get to know her sibling.
Thank you. Thank you very much. We will obviously review the arguments put forth by you today. Thank you and take care. Next matter for argument is People v. Edwin Burgos. Yes, you may proceed.
Good afternoon. May it please the court. Ben Schatz for Mr. Burgos. I'd like to spend my time up here talking about the Rosario issue and making sure the court is clear, not only about what was withheld, but the scope of relief.
So the Rosario, we're talking about statements that were made by the wife, the defendant's wife. Is that correct?
There are statements made by the defendant. We're talking about statements made by the detectives about their interviews with.
Right, exactly.
Right.
Well, that's, yeah. Okay.
So
I'm sorry,
right.
yes. So we're talking about statements that were reduced to writing by the detectives of statements made by the wife. And also, we're talking about statements made by the 2 gang members, right? Or at least one gang member stating that he was the one who had actually ordered the murder of the victim.
That statement, Your Honor, was disclosed, the statement by the gang member. The other DD5 that was withheld, in our view, contrary to Rosario, is a statement by a witness who saw the shooting, who apparently knew my client, and who gave detectives false information, essentially about my client's involvement.
Okay, so in terms of the wife's testimony, one, what was the relevance of her testimony? And two, why would she not simply be a witness that the defendant could have called at trial?
Right. We're not talking about the wife at all. The wife did not testify. We're talking about the detectives and their statements. So Rosario requires the distribution to defense counsel of statements made by testifying.
I probably know what Rosario is. Okay.
So there's
a little bit, just a little bit.
So then you know there's a case in this court called People versus Lee that says when detectives testify, you have to turn over the DD5s that they create so they can be cross-examined. Here we know of at least two, and we have reason to believe there are many more DD5s that were in possession of the prosecution, that were written by the detectives, that were not given to defense counsel.
Is it your position that whenever a detective testifies that automatically, as Rosario, they must turn over every DD5 created by that detective?
That pertains to the subject matter of their testimony, right. So when their testimony is, these are the steps that I took in a particular investigation, defense counsel is entitled to know when they were conducting the investigation, what reports they prepared in furtherance of that investigation.
So, well, in furtherance of the investigation, because they spoke to the wife prior to the actual, before there was an actual case, right?
No, they spoke to the wife when Mr. Burgos was a murder suspect in this case, right? So there were two shooters. Indisputably, my client is not the shooter who actually killed the victim. There's a second shooter. The detectives interviewed Mr. Burgos' wife and a number of other people, and we only got some of those reports. And under Rosario, that just can't happen.
Did the detective testify about what the wife told him?
No, the closest the detective comes and says, I went and interviewed the wife. That's
under your view, that's enough for you to get every DD5 that
unquestionably, because otherwise there would be no point to Rosario, because the prosecution could just not ask questions on direct, leaving defense counsel without any basis to cross-examine the witnesses about very valuable
If they don't ask questions on direct, they're not going to prove a case, are they?
I'm sorry, I didn't hear you.
If they don't ask any questions on direct, they don't have much of a case.
Right, but they could really pick and choose what they focus on direct, and if Rosario didn't require the disclosure of their statements, defense counsel, as he was in this case, would have nothing to ask the detective about with respect to avenues of investigation that he may have overlooked.
Did you preserve this argument?
Yeah, so this is very well preserved. There's a colloquy at around page 364 to 367 of the record where our client's trial lawyer says, I want all of these DD5s, I want chapter and verse on this, making clear that Brady is one thing. Brady is about exculpatory information. This isn't a Brady issue. Rosario's much broader. If you're getting a witness up on the stand to testify, defense counsel is entitled to have every statement that witness said that pertains to whatever he's testifying about.
So is there also any consideration as to whether or not this information is critical to your defense?
Absolutely. And
so how would this information be critical to your defense?
Well, it's a great question. We have no idea what it says.
Oh, okay. But that goes back to my other point, because my understanding was that the wife was still available, right? So could you not have called the wife to testify?
It's not a question of calling the wife. It's a question of crossing the detective about his interview with the wife, crossing the detective about his interview with other witnesses who saw the shooting. So that's what we need to have in order to do effective cross-examination, and that's what Rosario said.
But the detective didn't testify about what the wife told him. So what are you going to say? Is it true that you interviewed her? It's not true you interviewed her. That's all you can say.
But that's why the rule isn't limited to what she says on direct. That's an incorrect reading of the rule. There is no support for that in Lee and the Court of Appeals.
So I'm sorry, I do not understand. The detective simply testified that he interviewed the wife. He did not testify as to any substance of the interview. Is that correct?
That's correct. Yes.
Okay. So what is it now? You want the DD5 stating that he interviewed the wife, but she said nothing?
No. It's a really long interview, and it's blocked out in black text. And so we have no idea what the detective did in the course of his investigation. And our entire theory was the detectives got this wrong. They too soon focused on my client. They didn't do enough interviews, and the information they got during the interviews they did do should have led them into a different direction.
I'm sorry, I thought the record was clear that you did receive DD5s, did you not?
We received some, and then the prosecutor made clear that he was had a very strict reading of Rosario that did not require him to disclose any information related to the homicide. But the homicide is the incident that he is investigating on. And
what does that have to do with the wife?
It has to do with the wife because the detective is interviewing the wife. And so we know that the prosecutor did a whole bunch of interviews, the detectives did a whole bunch of interviews, gave the DD5s to the prosecutor, and the prosecutor then decided what was disclosable and not, and that's exactly what Rosario says can't happen.
Thank you.
Thank you.
So were none of these DD5s turned over as Rosario?
So DD5 number 91, which is the DD5 that memorializes the confidential informant who falsely claimed to have seen defendant shoot the victim point blank, was not turned over as Rosario. And then DD5 number 75, which talks about the visit to the wife, that was disclosed in redacted form. The only portion of the DD5 that was redacted was what the wife said during the interview. That portion of the DD5 wasn't relevant to what the detective testified about because he simply testified that among the steps he was taking to locate defendant, he had interviewed certain people. The wife was one of the people he met with. What she said during the interview, what she said about the incident, really had nothing to do with his testimony. And I think the case on point here is, People v. Harrell, where the prosecutor brought out that the victim had a prior conviction. There were statements she had made about that conviction, and those statements were deemed not to be Rosario material because the prosecutor really just brought out the fact of the conviction for just the narrow purpose of kind of anticipating, the fact that this conviction might have come out on
But why would not the statements made by the wife be relevant to the homicide?
Well, I mean, the statements might be relevant to the homicide generally, but they're not relevant to what to the detective's testimony. And the question really is, are they relevant to the detective's testimony? I think the two cases that are really interesting here are People v. Barclift and People v. Bamberg, where the DD5s talked about a series of drug buys that had been made on a certain day. The detective had testified about a subset of those drug buys, and the other drug buys had been redacted from the version of the DD5 report that was produced over to the defense. And the defense's theory in that case was very similar to the defense's theory here. Is, if we knew something about those other drug buys, they might reveal some other flaws in the investigation. They might reveal some other, issues with the evidence generally. But that didn't make them Rosario because those other drug buys weren't relevant to what the detective talked about. So, here, whatever the wife said, it might have been relevant to the case generally, but it wasn't relevant to the detective's testimony, which is why it's not Rosario. And, I think it's also just extremely important to note here that the defendant has the burden to show prejudice. That's in the statute, CPL 240-75. It's the defendant's burden to show prejudice. And the defendant has just utterly failed to show how this statement from this confidential informant who was lying, falsely claiming to see defendant shoot the victim point blank, which we know didn't happen.
And there's agreement from all sides that informant was incorrect, right?
So our position is that he was lying. How I read defense's brief here is that they also certainly they believe he was lying, that he claimed to see defendant shoot the victim. I think I also read them as saying that his whole account was false, but that's my reading of their brief. And the issue with his account is that it was just completely contradicted by the medical and ballistic evidence, not to mention the accounts of all the other people. So you got to ask when you're evaluating prejudice, how could this really have affected the trial? This guy who came 6 months after we had already identified defendant as a suspect in the crime, put up wanted posters all around the neighborhood. 6 months later, this guy comes with a bogus story that's completely contradicted by the medical evidence. How could introducing his statement have affected the outcome of the trial? And again, I think it's the same question with this statement of the wife. I mean, if the wife had a different version of events that was material that would have changed the outcome of the trial, they could have presented defendant's wife as a witness. She was sitting in court throughout the whole trial. She was clearly supporting defendant. And People v. Foster says the question is whether
the fact that they have the ability to call the wife as a witness, that doesn't clear you of your responsibility if it is in fact Rosario to return it over, correct?
Oh, of course, yes. I mean, I'm talking about whether it was if the court were to find that it was. I'm talking about prejudice, exactly. So, I mean, first of all, her account of the shooting was available, so there's no impeachment material that was unavailable to the other side. And then the other question is just look in a case where we have two of defendant's neighbors who knew him personally for about a year, saw him handling this gun. That was the only question: was he handling this gun and with the intent to use it unlawfully? They saw this shooting from very close, as we detailed in our brief, and their account was corroborated by multiple witnesses, both Edward Green, who's the bus driver, who's just a normal person going about his day, the victim's wife, the victim's girlfriend, also Sabor Bagui. All these people corroborated the eyewitness accounts of these two neighbors who knew defendant personally. What effect is statement from his wife going to have to change the outcome of the trial? We ask that you affirm. Thank you.
This isn't a sufficiency argument. This is a fairness argument. It's about what the defense is entitled to have when he goes to trial. I'll just start with prejudice because I think that's completely wrong. It's incredibly unfair to say we can't show prejudice when we don't have the documents. My adversary and I agree on a remedy, which is to hold the appeal in abeyance, send it back, ask the trial prosecutor what DD5s he didn't disclose because of his misunderstanding of Rosario, have those disclosed, and let us argue why it was unfair that we were unable to cross-examine the detectives using those documents. His example about another case where there's different buys that they weren't allowed to use, that's completely distinguishable. This is one incident.
Could not you have found out what the wife said to the detectives by asking the wife and then cross-examining the detectives as to what was stated?
In theory, absolutely. Put the wife aside, putting aside the fact that we don't know what else is not disclosed with respect to the DD5, that is the subject of the detective's interview with the wife. Think about the other DD5, DD591. That's a confidential informant who gives a very long narrative, indicates that he knows Mr. Burgos, indicates that he was at the scene, that he saw the shooting, and then gives a very almost blatantly inaccurate description of the events that happened. The detective shows him a number of photographs, asks him questions about who he can identify in those photographs. This is just what we can glean from the unredacted portions of the DD5. And counsel doesn't have that information to ask the detective, you had information X, Y, and Z at this time. You could have pursued avenue of investigation ABC. This is the sort of cross-examination.
But we knew that the CI was not telling the truth. We knew the CI was not truthful, right?
Right, and so we have to be able to find out what the detective knew at any given point during the investigation. It's not about the CI. We're not saying the wife had information and she could have got on the witness stand to share that information. Our defense was that the investigation was inadequate, that it too hastily settled on my client as the second shooter, and it was crucial that we be able to ask the detective.
They had two eyewitnesses.
I'm sorry?
They had two eyewitnesses.
And if we had...
I'm sure you could have argued that to the jury. They had two eyewitnesses. You could have told that jury why the eyewitnesses were mistaken or why it was insufficient. Clearly, they didn't believe you.
Judge, if we had a fair trial and the jury concluded that the two eyewitnesses were credible, fine, we have no argument. But we're having a trial with our hands tied behind our back because we don't have
discovery. Your hands are tied because we don't know what the wife said to the detective, although you could have called the wife. Your hands are tied because the CI, we know, was not being truthful. And also, I think counsel conceded that he or she was not going to call the CI at trial. I'm still not understanding how you...
Let me give you another data point, which is that the prosecutor says, these are just the two examples we have, right? And our position is that there are many more because the prosecutor is operating under this very, very narrow definition of Rosario.
I know you keep saying that, but I mean, the ultimate determination is made by the court, not by the prosecutor.
No, it's made by defense counsel, and that's the entire point of Rosario, is that defense counsel needs these materials to decide what is relevant.
No. If defense asserts to the court or argues to the court that this is Rosario and therefore it should be turned over, is it not then on the court to make a determination as to whether it's Rosario or
No,
not?
that is what Rosario overturned. That was the old rule, and Rosario.
Wait, so
says-
defense counsel say what Rosario is?
Yes, absolutely. He said it's the detective's statements about the investigation. They're testifying about the investigation.
I gather everything under the sun will be Rosario.
Yeah, absolutely. And the prosecutor said
Absolutely.
he is entitled to every statement made by any testifying witness that relates to the subject matter of the testimony. And the prosecutor says there are other materials I'm not handing over. We know there's a universe out there of materials that we didn't get at this trial. And it went straight to the heart of the defense. All we're asking for is a remand to explore the issue. Thank you.
Thank you both. Marlene H versus Lauren D.
Good afternoon, Your Honors. As a preliminary matter, the court should not even consider appellant's brief because the brief was filed almost 5 months after this appeal would be deemed dismissed under Section 1250.10a of the Rules of the Appellate Division. The deadline set by this court for perfection of the appeal in September of last year was 60 days after the filing of the transcripts. The transcripts were filed in September.
Counsel, let me ask you a question.
Yes.
When the respondent indicated that he wanted to go to represent himself, did the court question him adequately about that decision?
You mean in terms of doing a searching inquiry about
Yes,
whether he understood the
kind we
risks?
require, right?
Yes. I can see that they did not do a searching. The court did not do a searching inquiry, but the appellants.
Doesn't that require us to send this back for a new hearing on that issue?
Well, we're arguing that issue was not preserved for appellate review. I mean, the respondents or the respondents below, the appellants in this court, had a second opportunity to be assigned 18B counsel. He had 2 opportunities, actually, once at the very first appearance on the family fence petition and once at the appearance on his motion to vacate.
But doesn't he have to be informed of his rights and whether he has the right, and also does there not have to be some type of inquiry as to whether he has the ability to represent himself?
I would agree that there would be, but in this case, with the argument that I started with was actually that this appeal was perfected in an untimely fashion. At the time that this appeal was perfected, the appeal was already deemed dismissed. The deadline had already passed, and his counsel did not make a motion to extend the deadline. She did not make a motion to vacate the dismissal. So our position is that this appeal, that the brief should not even be considered. I mean, with respect to counsel.
Well, that red light means your time's up, but thank you. Next matter for argument is Alberico versus LDG Builders.
Good afternoon, Your Honors. May it please the Court, Michael Kazores on behalf of the defendant appellant, Riverside. There's 2 main issues that are the focus of our appeal. The first is whether Riverside gets the benefit of Section 11 of the Workers' Compensation Law. As laid out in our brief, we believe that the plaintiff's employer, Nest Seekers, and Riverside are 2 halves of the same whole. Essentially, Riverside, a wholly owned subsidiary of Nest Seekers, was created solely to own the property that was going to have Nest Seekers operate their business out of.
So it created that entity presumably for financial benefit to itself, but you're now saying that even though it got that financial benefit, it should also be given the financial benefit of being treated as plaintiff's employer, which would relieve it of liability here.
Well,
why shouldn't it be the case that
they're not
that your
mutually
client chose
exclusive.
a structure that gave it certain benefits, and it has to bear both the benefits and the liabilities
But
of
then,
choosing
Your Honor,
that structure?
why don't we throw out all the cases that where, for example,
I think we should talk about this case.
Well, at Capabella, there was a case where the car dealership was being operated by one business owned by the same gentleman as the LLC that owned the property.
But the fact they're owned by the same entity, the same person, is not sufficient.
But it wasn't in Capabella, so why isn't it here?
Okay, so here now, Riverside did not, there was no evidence that Riverside that net seekers exercised any day-to-day control over Riverside. Riverside maintained its own bank accounts, correct? Filed separate tax returns, correct?
Correct.
Rented the premises to new seekers pursuant to a written lease. So just given the fact that there are separate tax returns, that there are separate bank accounts, no day-to-day control over net seekers.
Well, Your Honor, we concede that there was separate bank accounts and separate taxes. However, both entities were controlled by Eddie Shapiro. Even though there was a written lease, Mr. Shapiro signed the lease both for the tenant and the landlord.
Yeah, which I find to be very interesting because he signs under tenant and landlord on the same date. So how can you be the tenant and the landlord? Under the lease agreement, where the landlord has certain obligations and the tenant has certain obligations.
Because he's the principal of both entities. He's the owner and principal of both entities.
Okay, so this is back to my colleague's question. It seems as if for certain purposes, you want to be separate entities, and for other purposes, you want to be the same. You have to pick one. Just choose one.
But, Your Honor, every case that involves this
you know
issue-
what? There are 22 cases on today's calendar. We are only talking about your case, okay? We want to focus on your case
Well, I'm talking
and
about
the facts presented here.
I'm talking about the case law that we relied on in our brief.
Right, and so we're somewhat fact specific. So again, we're back to the fact we have separate bank accounts. We have separate tax returns. We have no supervision by net seekers over Riverside, right? So again,
I disagree with that because Eddie Shapiro exercised control over both of them. He was the owner of and principal of both entities. He created Riverside to operate nest seekers out of 100 Riverside Boulevard.
So you would agree that they were formed for different purposes, correct?
Yes, I would agree with that.
Okay. And you would agree that neither is a subsidiary of the other, correct?
Yes, that Riverside is a subsidiary of nest seekers.
How do you show that?
Eddie Shapiro testified to that in his deposition.
So their finances are not joint, correct?
They have separate bank accounts and filed separate tax returns,
So their
yes.
finances are not integrated, correct?
Well, they paid expenses interchangeably in connection with the...
All right.
All right. Your Honors, the next argument is the
one that you will make on rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Michael Peters with the law firm of Siegel and Coonerty, representing the plaintiff respondent. There's really only one issue raised on this appeal, which is properly before this Court, and that is the issue that was discussed by my adversary while he was up here, and that is the question of whether or not they're entitled to a workers' comp defense on the theory that they're an alter ego, that Riverside is an alter ego of defendant nest seekers. The other issue that they raised, the issue of notice, was not raised in their motion for summary judgment.
Focus on the alter ego aspect. I mean, he's arguing that he is, they're one and the same. Net seekers and Riverside are one and the same. But, you know, they have separate bank accounts. They have a host of other things that are not separate. But still, the argument is you got one person he's got feet in both sides. So therefore, there's an alter ego.
Well, with all due respect, the case law says that that's not right. The case law is very clear that the court should consider multiple factors. The fact that one entity is a subsidiary of another is not necessarily determinative on the issue of whether or not one is an alter ego of the other. You have to show financial integration. You have to show that the officers disregarded the formalities and treated the two entities as one and the same. And in this case, they entered into a lease agreement where where Nest Seekers pays $7,000 a month to Riverside. So are they writing a check to themselves? I mean, it's clearly two separate entities. They form two separate entities for specific business benefits and purposes. And now that there's a lawsuit against them, they want to take advantage of the workers' compensation bar.
Well, just as my colleague says, it says if there's one aspect they're going to argue for something else, but then they're going to have another aspect that they're going to argue for this case. It's like you got to pick one or the other. You can't be both, right?
That's correct.
You can't have it both ways, right? Yeah. I mean, you can't be an alter ego for one thing and not an alter ego for something else.
That's correct, Your Honor. And there are two cases, two appellate division cases, which are cited in my brief that go to the heart of this issue. Butchner versus Pines Hotel and Reeves versus Lakota Construction Group. In both of those cases, the employer and the defendant claimed that one was a subsidiary of the other. Yet the appellate division in both of those cases found that they were not entitled to an alter ego defense for some of the reasons that were listed earlier. They maintained separate bank accounts. They had separate tax returns. They did not commingle their assets. There was no evidence that one entity controlled the day-to-day functions of the other. And that's what we have here. And so I would respectfully submit that the lower court got that issue correct and that the decision should be affirmed.
Thank you.
Your Honors, the second issue that I wanted to discuss was...
Counsel, I just want to get back to one thing that you said. Is it sufficient to establish that one is a subsidiary of the other simply by the testimony by Mrs. Shapiro? Should there be any other evidence or any other documentary proof in the record of that relationship?
Well, there probably is, but it's not part of... It wasn't developed in the case.
Well, that's what I'm saying. Should there not be something in the record on appeal about that relationship, that one was a subsidiary of the other?
Well, Your Honor, it's clearly this panel thinks yes, but we didn't think that at the deposition we thought it was sufficient. No one questioned it.
But you're arguing, and I assume you argued to Supreme Court that the alter ego, one is the alter ego of the other. So I would have thought that you would have put in something to show that they are subsidiary, that this is a subsidiary relationship, other than Mr. Shapiro's testimony.
That wasn't part of my control, Your Honor. I'm the appellate lawyer on the file.
I'm sorry. Continue.
With regard to the notice issue, concededly, we didn't raise the notice issue as part of our motion for summary judgment.
Why should we address it?
I'm sorry?
So why should we address it?
Because the plaintiff raised it.
Excuse me. If you didn't raise it in your motion, why should we address it now?
Because the plaintiff raised it and the issue was fully briefed and it was part of the Supreme Court's decision. And under
Did you raise it on appeal in your reply? Because I looked at your reply papers on appeal here, and you just hammered away at the alter ego because they, on the other side of the respondent's briefs, you're looking at me inquisitively. I read your reply brief on appeal, and it didn't talk about the notice issue.
Yes, it did, Your Honor.
Okay. All right, I'll go back and
that
look
was
at it again.
a large focus of the reply brief in addition to the original brief.
Your reply brief
Yes,
here. Okay, I'll
absolutely.
take a look at it again. Apologies if maybe I've read 22 cases and they all kind of blurred together.
Yeah, under the Gerdowski case, it's something that this court can consider, notwithstanding that it wasn't part of our main motion. Thank you.
Thank you. Thank you both. Chopra versus Gayo Kaku Japanese Barbecue Restaurant. Did I mix one? Oh.
Chopra. No, fine.
What did you do? Chopra.
Good afternoon, Your Honors. Mark Albert for the appellants. Your Honor, there are two things that the defendants were required to show to prevail on this summary judgment motion. One, that the condition, the one-step platform that my client fell off of, was open and obvious as a matter of law, and the second, that it was not inherently dangerous. Critically, Your Honors, whether a condition is open and obvious under the law cannot be divorced from its surrounding circumstances, and that's incredibly important in this case. On the way into the restaurant, Your Honors, my client went down a long aisleway with the one-step platform in his full view the entire way, stepped onto the platform, and then was seated at the table. when he was seated at this U-shaped table where there were patrons, his family, all around the entire end of the U-shaped table, including the open end, his back was literally to that platform.
That step was also illuminated, correct? It had light.
So it's a good point, Your Honor, because it was illuminated from the bottom side. So on the way, as you're walking to the table, you can see it on the bottom side of it.
You couldn't see it when you're on top.
You couldn't see it from the top. And so the big issue as far as the case law and the way that I see this is that the appropriate inquiry is not whether or not this was an open and obvious condition on the way into the restaurant where the step was in full view of him the entire time, but rather when he was getting up from the table, when the step was now behind him 18 inches and one step catapulted him off the platform to the level below. Your Honors, we felt that it was incredibly important to get an expert on the case because we wanted to be able to show the exact amount, the exact measurement that separated.
So your expert said it was 18, it's 18 feet?
18 inches, Your Honor.
18 inches, right.
So 18 inches. Now, the defendants knew very early on that we had an expert because we did an expert inspection, but they chose not to get an expert on the case. And in fact, they have argued throughout the entirety of the course of the case and to the lower court that the appropriate inquiry is as the plaintiff was entering the restaurant. Hours earlier, yes, he entered the restaurant, he walked down a long aisleway, and we would not be here if he fell during the entrance.
So the 18-inch space, that's not in dispute.
There's been no, certainly no testimony during the course of the case and no evidence produced by the defendants to the contrary.
Well, they do state that it was in compliance, that the steps was in compliance with the building rules, with the Department of Buildings, right? And applicable laws and rules and regulations and also the building permits.
Your Honor, they do say that. What the Department of Buildings said when they come to inspect this is really of no effect in this case. Frankly, what the court has to decide is whether or not this was an open and obvious condition, and I don't see how anybody could find that an open and obvious condition that's 18 inches behind you and one step will take you off the platform, how that possibly could be open and obvious.
May it please the court, Mr. Dominic Pintavalli for defendants, respondents, Morris and Mahoney LLP.
You did not put in anything in opposition to their expert's report, or you didn't put in an expert's report?
We did not, no. To tell you the truth, we didn't feel it necessary. I mean, there's no dispute that the platform is, or the booth is 18 inches from the platform step. However, I would just like to add that.
Yeah, but when you look at the photographs and you look at the photograph as you're departing, like from the steps, right? So if you're walking out, you can't, you don't really see it, right?
I'm sorry, Your Honor?
You don't really see it. There's no illumination, so you really would not be able to see the step. And that coupled with the testimony that there was another bench that was placed there so that the plaintiff apparently had to actually go out backwards, right? Because he's sliding around to allow his wife out from the seating.
All right, so the lighting with the step, it was lit with an LED strip under the actual step, but there was also a light fixture directly over the step.
Their expert was saying that, putting all that aside about the lighting and whatever there, the way I read the expert, maybe I read it wrong, was that it's not enough, there wasn't enough space there between where he came out of the booth facing everybody, because he slid out of the chair area, right? That he took the step back, and that's when he fell. And the statements, or at least the affidavit of the expert, or the testimony, was that there's not 18 inches is insufficient enough.
Right, so the expert did say that. However, as we mentioned earlier, the
did not say that or did say that?
I'm sorry?
Did you just say he did say that or did not say that?
No, he did say that. The expert had said that. I would just like to add that the step itself was in compliance with all the DOT regulations.
You're relying on that fact that you complied with all the codes and everything, but still, at the end, you may have complied with the codes, but depending on how you implement it, how you position everything, just because you comply with the code, that's fine, but if you put a table right at the edge, even though you complied with it, where you put the table could be, arguably, not a good thing to do, right?
I would agree, Your Honor. However, the expert in this case did say that the plaintiff appellant could actually only step forwards or backwards. They actually have the ability to step to the right as well. So the only It wasn't the only way to get out of the booth was to step back.
No,
So
after,
what was there that required a customer to know which direction he was able to step safely when getting up from the table where he presumably had dinner and maybe something to drink or whatever? Is there anything that would require, I mean, why should the customer have to know what direction he's required to step towards in order to not be injured?
I would agree that that's not on the customer, but prior to the accident, he did appreciate the step because he ascended it.
And he's supposed to remember that during dinner so that when he gets up from the table, he knows where he's supposed to step?
Well, that's actually been found in Martinez, which was in my brief, Masker, Graffino, and Nelson.
Well, the expert actually said that the mere fact that he would have to, I mean, I understand that you're stating that he could have taken a turn, but the expert said that the mere fact that one of the ways in which to descend was to go backwards, that in and of itself showed that there was a dangerous condition.
Maybe
or that
so.
The setup was dangerous.
Maybe so, Your Honor. But again, I'd just like to point back to the code specifically mentioned in the appellant's brief. It was code F1637, section 6.2.2, titled Short Flight of Stairs, 3 or Fewer Risers. Specifically in that code, they list delineated nosing edges, contrast in surface colors, and accent lighting.
Yeah, so these are all cues. These are handrails, delineated nosing edges, tactile cues, warning signs, etc. But I think as my colleague mentioned or alluded to, it depends on the situation, right? And it depends on the setup. So perhaps in this particular setup, as per the expert, the fact that you have the illumination underneath the step is insufficient, and the expert says that you actually needed some type of a ramp. But thank you.
Thank you.
Your Honors, I'm not going to be very long. This plaintiff was put in a very difficult position. He got up from the table. He literally could not take a step forward because there was someone seated on the open end of the table, and the only thing that he could do to let his wife out was to step back, and one step catapulted him off the edge. I would say that the platform in the other area of the restaurant is instructive as far as what should have been the setup here, because what they had was they had the table that was much further forward, and Your Honors have a picture of this other platform in the restaurant so that someone could get up from the table, appreciate that they had to step down, and in that particular area they had handrails with 2 steps going down. In this particular case, there was just no way that he could have appreciated the one step. He would have, as the expert indicated, would have had to turn around, see where he was, and look down before taking a single step, and I would just...
But there was testimony from the defendant's witnesses, the waitress, and I think maybe the manager or something, that there had never been any issues with the steps. No one had ever complained. None of the wait staff had ever had any issue in terms of descending or ascending the steps, and no patron had ever had any issues.
So, Judge, that's a very good point. I would only say that in this particular instance where my client was very seriously injured, he had a fractured humerus with surgery and hardware and the whole 9 yards, they didn't even take an incident report. So I'm sure the next time that somebody falls, they'll say the same thing, that nobody complained and there were never any prior incidents. Thank you, judges.
People v. Vladimir Kroll.
Good afternoon. May it please the court. Alexandra Mitter on behalf of appellant Vladimir Kroll. After deliberating for 5 days on a 6-day trial and deadlocking twice, the jury acquitted Mr. Kroll of half of the charged incidents here. But the complainant's testimony was equally unbelievable and uncorroborated as to all of the alleged incidents. And this court should reverse the remaining convictions and dismiss the indictment because Mr. Kroll's conviction is against the weight of the evidence. There's absolutely nothing here that corroborates the complainant's tale of stolen kisses and sexual conduct in public places, and it's just implausible on its face. Mr. Kroll is a military veteran who was rising through the ranks of the NYPD, had no prior...
Are we supposed to infer that he won't engage in improper sexual conduct?
Well, it's certainly appropriate for this court to consider the fact of the prior good conduct of the defendant when engaging in weight of the evidence review. But I think more importantly here are the enormous problems with the complainant's testimony. The complainant's mom, it is admitted and conceded by everyone involved that she performed random checks on her daughter's cell phone, never found a single inappropriate message between my client and the complainant. The only time she found an inappropriate message was when she found the complainant sexting with an 18-year-old boy in her school, and that's what set off this whole chain of events to begin with. And, well, she deleted the text messages, you might say. But the police recovered nearly 2,000 deleted text messages on her various devices. Some of them were from Mr. Kroll. Not one of them was an inappropriate text message. Her description of the tattoos,
So why were they deleted? The 1,912, I think, messages, why were they deleted?
It's hard to say why they...
Did she testify that it was because the defendant told her to delete those messages from her iPad and iPhone?
All of the deleted messages that were recovered were not between her and Mr. Kroll. They were
I understand
deleted
that,
from a
but
variety of sources.
Was there not testimony that the reason that those text messages were deleted was because the defendant told her to delete the text messages?
That is indeed what she testified to, and the text messages with Mr. Kroll that were in fact recovered were completely innocuous text messages.
So in terms of the evidence and the weight of the evidence, were there not certain circumstances or certain incidents where she was clear as to date, time, and place, as opposed to other instances where she was not clear as to date, time, and place?
She was clear as to date, time, and place on all of them, Your Honor, and the problem is the extensive details, quote unquote, that respondent cites in its brief. They were unbelievable details. The complainant was alleged to have engaged in sexual conduct with her in a CVS parking lot in the middle of the day. That just defies belief. That is not how people behave, and that's particularly not how people behave when they're engaging in illegal activity.
That's not what people behave. I mean, unfortunately, I think some people do in fact behave in that way. But the point is, why could the jury not make a determination as to whether the victim, the complainant, was credible as to certain incidents and not credible as to others?
They certainly are entitled to make that determination, but Your Honor, I will be frank, I have had this case for going on 5 years now. I have tried to parse how they drew the line where they did, and I think at the end of the day, they just gave up. They deadlocked twice in this case. The second deadlock happened on a Friday afternoon at 4:10
Right, so
PM.
there were a total of 17 notes, I think, something like that. And then there was at least 1 or 2 Allen charges, right?
There was 1 Allen charge, but importantly here, I think the jury deadlocked on a Friday afternoon. The court did not deliver an Allen charge until the subsequent Monday morning, after which they returned a verdict in under 2 hours.
And if the judge had given an Allen charge that Friday afternoon and the jury had returned a verdict, you would have said it was a coercive verdict. It was a coerced verdict.
I'm not
So, I mean, you know what? We've all been there, or at least I've been there, and a couple of us have been there. We wouldn't give an Allen charge on a Friday afternoon because, you know, that's what the defense is going to say. You coerced the verdict because the jury wants to go home for the weekend.
Sure.
But again, I'm not sure, what is there in the record to substantiate your argument that obviously, you know, they could not credit her testimony as to certain incidents and not as to other incidents?
Well, I mean, ultimately, it's on the people's burden to prove the case beyond a reasonable doubt. And I think here, the split verdict in this case underscores the weakness of the case as a whole. There is no basis to parse between the convictions here. Her testimony is incredible as to all of it. And the fact that they kind of gave up on a Monday morning, I mean, if that's proof beyond a reasonable doubt, giving up after deliberating for as long as the trial.
Your argument that her testimony was incredible as to all the incidents is based on what?
It's based on the fact that she's describing these high-risk scenarios, public sex happening between an alleged...
She's alleged to have sex with a minor. It's all high risk.
And if you're engaging in high-risk activity, with all due respect, I don't think you're doing it in a CVS parking lot at 11 a.m. in the morning.
Well, again, you know, we've seen a lot of cases where it's CVS. I think one incident here was Target. I mean, you hang out here the rest of the day, you'll see a lot of cases that you might find unbelievable. She also testified, I believe, that she actually was enamored of him, right? That she had feelings for him and she loved him.
Yes, and I think that with all due respect, that's irrelevant to the issue here. The issue here is her testimony is uncorroborated as to the sexual relationship. And
the medical testimony, there was some medical testimony, right?
And the phone records.
And there were,
Phone records.
Well, the phone records don't show anything inappropriate. The phone records show...
There's extensive communication between an adult and a child.
At night. I mean, I think a 13-year-old child. And I think there were some telephone calls that were in the evening, right? At night?
Late at night.
Late at night.
It's indisputed that they had a father-daughter relationship. And frankly, if this was a
I hope
biological
fathers don't act like that towards their daughters, but you have time on rebuttal.
Good afternoon, Your Honors. May it please the Court. Elliot Robert Hamilton for the Office of the Bronx District Attorney. As all of Your Honors have pointed out, the jury carefully reviewed and weighed the evidence over a 5-day deliberation period after reviewing the phone records, the photographs, the defendant's testimony, and the victim's testimony.
So how do we...
counsel,
Go ahead.
is it your view that the distinctions that the jury drew as to what they convicted of and what they acquitted on corresponds to the strength of the testimony as to each of those allegations?
It was the strength of the testimony and the additional corroborating evidence. Each of the incidents in which he was found guilty had some other form of ample corroboration, including photographs with respect to the father-daughter breakfast, the testimony from the defendant, the victim's mother, and the victim as to the babysitting incident, and the text message exchange between the defendant and her mother with respect to planning out events and activities in honor of her doing well in school. All of those were taken into account along with all of the other evidence with her very specific and detailed testimony that talked about the locations, the nature of the sexual contact, the resulting pain that she ended up feeling, the emotional attachment that she grew over a long period of time in this calculated pattern of grooming, as well as the nature of this, as well as the fear of being caught by her mother, and also the fear of the defendant being caught and ultimately arrested for all of this. All of this information and all of this evidence was taken into account by the jury, and they carefully looked through all of it, and much of the court file shows that the jury notes had the jury look at all of these issues and look at all of this evidence in carefully constructing a verdict. The fact that the defendant was acquitted on some of these incidents merely shows that the jury took the reasonable doubt charge seriously. Additionally, Your Honors, I want to point out that the defendant makes a lot of arguments of alleged prosecutorial misconduct. All of that is unpreserved, all of it is meritless, and the interests of justice are not served by reversing a carefully constructed split verdict based on specific and detailed and corroborating evidence that on the matter of unpreserved and meritless allegations of prosecutorial misconduct. If there are no further questions, we ask that you affirm the convictions.
Thank you.
Thank you.
So I didn't hear an answer to Your Honor's, I think, important question, which is there a basis to parse between the facts underlying the conviction?
I heard an answer.
Well, the answer was factually incorrect. There is that he was acquitted of charges in which there was text messages showing that they were going to get Chinese food, for example, and he was convicted.
I think what he said was that he was convicted on the incidents where there was corroboration.
And what I'm telling you is he was also acquitted of counts in which there was an equal amount of corroboration as to the sort of innocuous aspect of the relationship, the fact that they went to Ripley's, believe it or not. There was proof of that. He was acquitted. So there really is no basis to parse between them. I think I'd like to take one moment to respond to the Molyneux point, which is respondent agrees that we're talking about Molyneux here. Respondent's point is just there was a permissible scope, but they're completely wrong on the permissible scope of these text messages here. There was absolutely nothing to quote unquote impeach Mr. Kroll with these sexually explicit text messages. He acknowledged that he had not cut off his relationship with the complainant's mother. He said he was kind of sort of trying to distance himself. That is not cutting off a relationship. And so he said that on direct, and then on cross, he continues to agree. They continue to see each other. They continue to speak almost daily. And so for the prosecutor to then get up there and confront him with text messages between two consenting adults that describe in explicit detail what I think a lot of people would probably consider non-traditional sex acts, gangbangs, forcible sex, being sexually used, that pushed this over the edge. In the absence of really any corroborating evidence here, the prosecutor's reliance on these completely irrelevant text messages whether it was propensity evidence or simply to just kind of gross the jurors out, I think the point was made. And there's absolutely no permissible purpose. And
Was there any curative instruction, or was
There
there a Molyneux instruction?
there was not a Molyneux instruction given. Counsel objected when the prosecutor tried to confront, or did in fact confront Mr. Kroll with these explicit text messages, and it was overruled, and that's the end of the record.
Thank you.
So we'd ask that you reverse the conviction. Thank you.
Dobkin versus Hub International. You gonna go? Or you gonna have this go? Please, God, I want to feel responsible.
Good afternoon, Your Honors. May it please the court. Andrew Curlin for appellants Eric and Barbara Dobkin and the Dobkin Family Foundation. Your Honor, this is a simple appeal because what happened below is the court granted a motion to dismiss filed by the defendants with respect to the First Amendment complaint in this action, dismissing two causes of action under the New York General Business Law. They're related. Section 349 deals with deceptive trade practices. Section 350 deals with false advertising. The elements, Your Honors, as you're aware, are the same. Defendant's conduct must be...
Counsel, how could your clients claim to have been misled when the record seems to suggest that they were not given personalized recommendations for the previous 30 years? So why would they still be expecting that?
Your Honor, as pled in the complaint, that is true. They were longtime customers of the defendants. However, they believed, essentially, they were duped, to put it simply, into believing that the services that were promised had been being provided all of this, the entire duration of their client relationship with the defendants. And that's because...
So they thought that the advice they got was personalized.
Well, that's correct. Essentially, they thought that all the steps that they were required to take, which is essentially to renew their homeowners insurance policies, which were provided by the defendants, were sufficient, and that their policies, which were through a reputable carrier named Chubb, were sufficient for their needs. So they thought that they were getting the services that they had been paying for.
But I thought the services were supposed to be personalized because they were high net worth individuals. So I thought it was supposed to be personalized services, but there was no personalized services. There was no communication really other than the renewal. So I'm not understanding how they could have been duped when they really were not receiving any information whatsoever. It doesn't seem to be a duping. It seems to be there's no communication as per the contract.
Your Honor, that's completely right, and you have the facts completely right. But essentially,
so how are they duped if there's no information?
Because, Your Honor, they were getting they did have a relationship with the broker. They were constantly in communication with respect to the fine arts policy, for instance, which the broker also facilitated getting. They assumed because they were paying the thousands of dollars in premiums every year that they had received the services. As pled in the complaint, they realized this was a complete mistake. They had not been getting the services.
Yeah, but that's a far cry from asserting a claim for general business law for deceptive practices was consumer oriented, because the promise was in the advertisement, this very puffery that we'll give you personalized attention, we'll give you a report. They never got any of that stuff. So that over the years, I mean, you even said 30 years worth, did they not realize, well, wait a minute, now you're going to go back and say, we didn't get anything for 30 years. That's a deceptive practice under the general business law. And like, what?
Yes, Your Honor.
You have your other claims that are still sustained, right? I mean, it's just a GBL that was dismissed.
Well, separately, it's not part of this record, Your Honor, but the other claims were subsequently
summary
dismissed.
judgment, right?
That's correct, Your Honor, and that is on appeal.
Well, that's coming up too.
Yet.
Okay, that's the next round. That's
You're
round
right.
2.
Well, we're not here for that today, Your Honor, respectfully. But the point of the story is, as pled in the complaint, they learned all of this after the fact, and they realized none of these services had been provided. But certain things had been successful over the years. They had 2 claims. One was for roof damage. One was for...
Yeah, but this is specialized. What happened here was a big deal, right? I mean,
You're right. It was millions of dollars, Your Honor.
Right. So, this is where the special policy triggers in, that high-end, clientele. This is where they're supposed to be protected, right?
Your Honor, you're correct. They were, at the time, about 78 years old. They're older than that now when this loss happened in 2021. They assumed that because they were paying so much over the years, they knew that Hub represented itself as being the preeminent provider of these sort of services. They assumed, unfortunately incorrectly, that these services had been provided.
That's what I don't understand. I don't understand how assumption equals deception. Because, or deceptive business practices. You assume, but then again, as my colleague stated, they're not providing them with any of this personalized information that is stated, I think, on the website and also, in the policy.
That's right, Your Honor. It is stated publicly on the website. It has really nothing to do with direct communication with my clients. However, I think to answer your question, we just look at the elements of the statute, which is the conduct. Again, these can be objectively determined by this court. The defendant's conduct needs to be consumer-oriented. It needs to be deceptive in a material or misleading way. Deceptive or misleading in a material way, rather. And then there has to be an injury as a result of this. So I totally recognize why the court is focused on the fact that they had continued doing this business all the time without getting these personalized services. Honestly, they believe that they had been getting them over the years, and that's what's pled in the complaint.
Thank you.
Thank you, Your Honors.
Good afternoon. May it please the court. Peter Bigging, Goldberg Segala for the respondents. I think the court is focused on some significant issues. The one issue I want to talk about is actually the statute itself is targeted at consumer-oriented conduct, not a specific dispute with regard to the level of services.
Counsel, I have a question a little bit to the side of what you're talking about now. In support of your motion, Mr. Biggings put in an affirmation to which he attached several documents. I didn't see anything that supported that those documents were ever actually provided to the plaintiffs. Can you show me where in your motion it shows that any of those documents actually were provided to the plaintiffs? That is, by somebody with personal knowledge. I assume Mr. Bigging didn't personally send them.
Yeah, I'm Mr. Bigging, yes. I don't have personal knowledge.
Oh, sorry.
That's okay.
I didn't catch your name. I apologize.
I'll have to look at the pleadings, but I know that in the pleadings they acknowledge, in the specific pleadings, they acknowledge that there were numerous communications
The
over
burden
the
is on
years.
you on the motion when you're asking us to consider the documents, the burden's on you to show that
Well, this was
they were provided. Where is that shown?
We've established this is documentary evidence that they've conceded that they received.
But where is it conceded?
I have to look it through the pleadings. I know that they testified that they had numerous communications over the years, and that I believe that they were provided with
They
proposals.
conceded anywhere that's in front of us on the motion, in the record before us? Because that's
Yes.
all we can look at.
They do concede in paragraph 57 to
Paragraph
receiving
57 of what?
of their First Amendment complaint, having received a personal insurance review. They claim they got that late, but they got that. They also concede that they were that Hub made available on its website recommendations regarding cyber risk, and they had actually a cybersecurity website, cybersecurity resources
So that doesn't
website.
address all of the documents attached to your affirmation, right?
That doesn't necessarily address all of them, no, Your Honor.
Thank you.
So with regard to the issue of whether this met the statutory requirement, however, the question is, was this conduct that was alleged to be conduct that was consumer-oriented, deceptive conduct?
Everyone. I mean, it's just
Everyone, as
right,
opposed to
not
just one
them,
specific
right?
issue, right? And if you look at their pleadings, they allege that, in very conclusory fashion, that this must have been deceptive because the advice they got wasn't sufficient.
Well, that doesn't satisfy the statute. The statute is, the next allegation should have been along the lines that we know that for other consumers, they have also failed in that regard with their representations about providing personalized insurance planning. Something
Right.
along those lines, that
That's
have like a broader concept
That's
rather than an individual situation as here.
That's exactly what Justice Crane stated in her decision, that there needed to be some additional allegations. And in fact,
I didn't see any case law that supported that allegation, though, that finding by Judge Crane.
that there needed to be some allegations. So the allegations,
Seems to me our case law is quite to the opposite.
the case law says that you can't make conclusory allegations. You have to provide some kind of factual support. So their allegation was, in paragraph 59 of the complaint, was that the representation that Hub was prepared to provide these types of advice and recommendations was false because in the year following the loss, the plaintiffs had sought additional recommendations and quote, Hub has failed to provide any meritorious recommendations to the Dobkin parties. So the argument is, because we didn't get any recommendations, meritorious recommendations, and we didn't receive any useful advice, that must mean that they didn't have the ability to provide that, and that must mean that it's deceptive. It's a difference between saying, I don't believe I got the level of service that was promised for me, as opposed to me making a misrepresentation to the public generally of my ability to provide that level of service.
That's the Oswego court, right?
Yes, that's the Oswego decision.
Laborers Local.
And there's actually a decision, Your Honors, that this court rendered in 2011, Golub versus Tannenbaum Harbor, 8883rd 622. It's very specifically on point. That's an allegation that the plaintiff was a homeowner, had two homes, claimed that the broker had failed to give him advice regarding ways he could save money on his insurance, one being that he could have declined a personal property coverage rider that cost thousands of dollars a year, and another was wind coverage for his home in Southampton. And the court said, the fact that you didn't get that advice and you feel that that was inappropriate doesn't amount to false and deceptive conduct, consumer-oriented conduct.
Thank you.
Thank you, Your Honor.
Your Honors, I'll be brief and continue with the argument that that my colleague was just speaking about. We distinguished other cases in the briefs, and so I won't go into it. But that one, for instance, including as just described by Mr. Bigging, there were no public statements at issue. That was just direct conduct between the broker in question and the aggrieved client. Here, we're focusing on the public statements as pled in the complaint. With respect to the case that Your Honor mentioned a moment ago, with respect to the Oswego case, rather, that makes clear that the element, the fourth element, if I may, that Justice Crane added into the statute does not exist. Rather, that case makes clear that the allegation needs to be that the conduct in question might potentially affect other consumers, not that it actually had. And it's designed to halt consumer frauds at their incipiency without the development of persistent
You just
frauds.
said potentially protect consumers, right? But if you don't have any allegations in that the consumer at large is being harmed by this activity, doesn't this create a single shot, one-shot situation with your client versus a consumer-oriented, broad base?
I don't think it does, Your Honor, and it might potentially affect other consumers. And I do believe that that's what is pled in the complaint adequately, especially because of the paragraph that my colleague mentioned a moment ago, where the Dobkins, the plaintiff appellants in this case, realized after the fact, once the veil had been lifted and they suffered this terrible loss, they met with the broker and said, hey, can you get us this service that you were supposed to have been providing us this whole time? Now we realized you haven't been. Lo and behold, they can't. They don't even have the ability to do it. So if anything, their loss has almost proven the point that the defendants in this case did not have the ability to provide the services that they promised. With respect to the document issues, the only way documents on a motion can overcome a complaint on a motion to dismiss is if they utterly refute and contradict the allegations in the complaint. Here, the documents did not do that, especially because, as Your Honor pointed out, they weren't even provided to the Dobkins individually. One, not until after the loss. The other two were not addressed to the Dobkins, and none of them were personalized, tailored to the needs of the plaintiffs, which is the services that the Hub provides and promises.
Thank you. Thank you both.
Thank you very much.
Shane versus Rosenwax.
Your Honors, in this appeal, the appellant is asking the court to grant her motion to renew. In the alternative, to remand to the lower court with instructions to treat and grant the motion to renew as a motion to amend her complaint, because the lower court has never decided the issues presented in the appellant's motion to renew. In the instant case, Barry Shane was a vulnerable pro se litigant that should have been given every opportunity to have her case judged on the merits. New York courts promote justice by shepherding each case to get to the
So
merits.
what were the new facts that were allegedly proffered by your client?
On May 6th, Your Honors, Mr. Fruiterfas, the attorney representing the defendants, made a false report accusing...
I'm sorry, I forgot. I want to back up for a second. I could not find the first amended complaint in the record. Was that, I had to go to NICEF. Why was that not in the record on appeal?
Yes, Your Honor. The reason is because my client did an initial appeal and asked to consolidate that appeal with this appeal.
And so the initial appeal, was that perfected?
The initial appeal was on the decision to dismiss her complaint. And this court rejected her motion to consolidate, and she missed the opportunity because she was waiting for a decision from the lower court to perfect her initial appeal. So only this appeal could be brought.
So now I'm looking at the First Amendment, the first amended complaint. Point me to the paragraph that now has the new information.
So that is why the appellant is asking the court to remand to the lower court to give instructions to treat and grant her.
What paragraph in the new amended complaint has the additional information?
So the appellant would like to amend the complaint to include the new facts.
So this is the first amended complaint. You want to amend this one as well?
Yes.
And what are the new facts that you're setting forth?
The new facts are that Mr. Fruiterfas, the attorney representing the defendants, called APS, Adult Protective Services in Florida, reported the appellant for elder abuse. The APS did a 5-week, very thorough investigation, interviewing extensively everyone involved with knowledge, and came to the conclusion that there was no credible evidence to support the defendant's allegations.
And this somehow, your argument is that this would show defamation on the part of the defendants?
Yes, yes, Your Honor, because according to the law, Mr. Fruiterfas was the defendant's agent, and they must own the act perpetrated by him, even though they may have thought that if they had him call in the report to ACS, that they could avoid any liability.
When did he allegedly make that complaint?
I'm sorry, I couldn't hear you.
When did he allegedly make that complaint?
On May 6th, 2022.
And wasn't that after the filing of the amended complaint?
Yes, it was. The amended complaint was filed in 2019.
So they concern facts that were not present at the time of the filing of the amended complaint?
Correct, Your Honor.
And that would be permissible?
If the court will remand to the lower court with instructions that the motion to renew should be treated as a motion to amend her complaint and a motion to renew, then yes, she would be able to amend and bring those facts before the court. They have never been presented. They've never been decided by any court.
So the Supreme Court dismissed, the Supreme Court did not allow the complaint and the amended complaint stating that there was a lack of specificity. So where is the specificity?
So, Your Honor, in numerous cases for defamation per se, particularly Lieberman v. Gelstein, which was decided by the Second Department in 1992, if a statement charges the plaintiff with a serious crime, it is defamation per se. This is a serious crime that she was accused of.
So don't we need dates, locations, and specificity in terms of the statements and what was done? Don't we need some dates, specific locations?
Yes, there's tremendous specificity in the 5-page report from APS.
Okay, thank you.
Thank you, Your Honor.
May it please the court, I'm Alan Fuderfast, the individual that you referenced. It's very interesting that the record on appeal does not include any documentation from the complaint that was filed with Elder Services back in May, nor is there any indication in the record of appeal of any investigation that was done, much less the result of that investigation. The claim that that investigation was thorough, the elder was thorough and lots of people were interviewed, it's just false, didn't happen. So this court has nothing but unsupported claims about the content of an elder abuse claim made by my client and the result of that. But let's go back to what's really going on here. Appellant had an opportunity to appeal the decision on the motion to dismiss. 148 in the docket sheet. This court, in fact, Judge Rodriguez, Your Honor, permitted like 4 extensions. The last extension said, this is going to be the last extension. You have till the January term, about November 7th, 2022, to file your appellate brief on the motion to dismiss that was granted, on the decision by Judge Saunders on the motion to dismiss. That date came and went. So all of this, I want to file a new complaint. I've got this. You had a motion to dismiss that was decided back in 2021 after 148
Well, that's what I wasn't understanding, but your adversary stated that they combined the appeals or something.
No, my adversary, Judge Weber, that's not what happened. What happened was, if you look at the decision in order, which is part of the record, imagine this. They're saying that it was an abuse of discretion by Judge Saunders, and that new documents, this new claimed information would have changed that prior determination. Where's the prior determination? Where's the decision in the record on appeal? Where's the decision on the record on appeal, 148, which was the decision on the motion to dismiss?
That's what I couldn't find in the record.
Exactly, which is point 1 on our point 1 or 2
And
on
then
our appeal. They never even completed the record.
The new information as to your report to Florida's Adult Protective Services, that came in, that was an unsworn letter or email or something that was attached?
There are, what was not provided to this court, I'll answer your Honor's question. What was not provided to this court is the motion to dismiss, all the exhibits, all of the documentation before Judge Saunders up to 148. Her decision on the motion to dismiss is 148. So she had 148 filings, numerous pro se filings, letters, accusations against everybody, wanting to sue this one, asking to amend the complaint. The record's unbelievable that Judge Saunders sit there and she allowed all this to happen. We filed numerous motions to strike, numerous responses in the record below. Judge Saunders gave this pro se plaintiff every opportunity. And what happened was, and by the way, the motion to dismiss concerns events in 2019. The amended complaint concerns events 2019. That's what the complaint's about. What she's talking about is something in May. But Judge Saunders deals with this because in 179, which was one of the few documents actually put in the record on appeal, Judge Saunders says right up front, plaintiff moves the court for a second time to re-argue the motion, which granted defendant's motion to dismiss on the complaint based on a lack of specificity in the pleadings and qualified privilege. And then she goes on to say that this new information, okay, was meritless, illogical, strange credulity and has no bearing on the motion to dismiss. This is not the first motion, because there was first a motion to re-argue, which is number 165. So after the motion to dismiss was granted, our motion was granted, which is 148, plaintiff went ahead and fired a motion to re-argue, which she doesn't put before you in the record of appeal either. And the pleadings about that are not in this record for Your Honor to determine. And in there, Judge Saunders also deals with the fact of the lack of specificity, the problem with the defamation claims below. So what she's saying in 179 is crystal clear. There's nothing about these new claims, these unsworn letters, one of numerous unsworn letters that were provided to the court below, that would change the problems of the specificity of the defamation claims in the complaint. And where are those problems contained? And I know I've got a red light. Those problems are contained in her order 148, which is the decision on the motion to dismiss, which appellant never provided to this court on a record of appeal. That alone is a basis to dismiss this appeal.
Thank you.
Thank you.
Your Honors, the defendants argue that the record is incomplete because the initial decision of the lower court and the second decision of the lower court were not part of the record. The record is complete. It is not incomplete. This motion to renew stands on its own. It cures all the defects in, if there were any, in the amended complaint, and it can overcome any motion to dismiss. According to CPLR 5526, everything that is required to be in the record on appeal is in the record on appeal. This court denied the appellant's motion to consolidate her initial appeal with this appeal. She was only respecting this court's decision by not including any documents other than those exactly related to this appeal of her motion to renew. Although the judge called this a motion to re-argue, she did that simply to ignore all of the new facts.
What was it? Was it not a motion to re-argue?
It was not. It is labeled a motion to renew, and she, in her decision, said, no, it's not really a motion to renew, it's really a motion to re-argue, which is not true. It was new facts presented. They were not in the amended complaint, but the appellant should have been instructed to put them in the amended complaint, to amend her complaint, and the new facts should have been brought before the court. Furthermore, the defendants are completely disobeying the proper procedure here. They need to make a strike to the appellate record if they do not accept it, instead of making a strike to the appellate record as is required.
There was no record to strike. That was the whole point. Their argument is that you didn't include anything on appeal, so there's no record to really strike.
There is an entire record on this motion to renew. And if the defendants don't think that it's adequate, they needed to make a motion to strike the record, instead of talking about how in their brief, asking this court to do something improper and to dismiss this appeal.
Thank you. I know, I couldn't help it. Valente versus MTA. I have to stop. I'm not asking any more questions. It's up to you. I know.
You guys trying to figure out who sits where?
He found his seat, so he's got his seat.
I've been voted to go first, Your Honor. If it please the court and co-counsel, I represent defendants Luis Mendoza and Village Doc, who were found liable below as a matter of law on one issue, which is collateral estoppel, because Mr. Mendoza chose to pay a traffic violation for allegedly changing lanes unsafely. There's a Court of Appeals decision called Gilberg, which tells us why the court below was wrong.
Counsel, I have a question. We now know that two of the plaintiffs died several years ago. There's never been an adequate substitution of their estates. How can we hear this?
So there hasn't been an adequate of the estates?
Of their estates. So how can we hear this case, this appeal?
I believe, Your Honor, that there has. I believe the case was filed in the Supreme Court.
When?
Oh. I have the plaintiffs, Daryl, the estates of both. I've rested on my papers to begin with, but there was a file.
Is it in the record before us?
No, that's the whole, that is the whole point. I mean, you're all here But that's the whole point.
That's why the
There's
five
no-
of us has a question about
Right,
that.
there's no substitution that's stated in the record. We have no substitution for, is it Darrell and Nancy?
Nancy and Douglas.
Nancy and
Darrell.
Douglas.
Douglas or Darrell?
Darrell.
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 Oh, Nancy Douglas.
Nancy and Darrell.
Douglas.
Right.
Darrell Douglas, thank
Right.
you. We have no substitution in the record as to those individuals
In
who.
front of us right
How can we hear
now.
this appeal?
Right.
Well, those are my clients, Your Honor, I understand.
Well, I understand, but this affects all of you.
It does affect all of us.
Yeah, it does.
If we can't hear the appeal, it affects all of you. I don't understand why all of you didn't somehow sit down and figure this out.
What?
It absolutely does affect all of us, Your Honor, and I agree with you.
Hey, that's a first.
Well, I'm sorry, tell me who you are.
I apologize, Your Honor.
Okay.
I'm Louis Bottolato from Fortunato & Fortunato for a co-plaintiff who is alive, thankfully, Jason
Good.
Lawrence. Now, my understanding was they filed a motion to substitute the estates in Supreme Court Bronx County. And that
When?
You know?
It was before we perfected the appeals. It was, we were holding off until they
So
got.
when was that filed?
I believe what was filed in this case under number 50, the stipulation was the stipulation to amend the caption to reflect.
That's different. That's not the same. If you're amending the caption versus an actual substitution, we can amend captions all the time.
I represent entities, I don't represent people.
Okay, who represents people? Okay, you represent people. So when has there been any filing of this substitution?
I thought there was, Your Honor.
And when did you think that was?
That's, well.
Is it in the record before us, counsel?
Oh, we have someone that's
Oh, somebody's standing up.
standing up right here.
Do you represent people?
Do you represent people?
I represent one person, James Smith, of Building Materials.
No, that's not.
Council, so I'm not aware of what.
That's not a people we need. We have nothing, in all seriousness, and this isn't, there's no need at this point that we can see to get to the gist of the argument because it affects the arguments for everyone and it affects the case. We don't have a substitution. There's no substitution in the record for Darrell Douglas or for Nancy.
Yeah, because the problem is if we go down this road, I mean, not to say this would happen, when someone's going to argue they didn't like the decision, hey, well, there was never a substitution. That case, you can't overturn that appeal. Go up to the Court of Appeals. We get reversed so quick, our heads are going to spin.
I completely agree with your position, and there's nothing we can really do right now if there was not a substitution.
Exactly.
My understanding was there was a substitution in Bronx Supreme.
Good.
That was my understanding. We received.
Don't take this the wrong, counsel, don't take this wrong way, but I got to see it on paper and in the record. I mean, I cannot vouch. This tape recording here doesn't do us very well when it goes up. You're so good, you don't have to deal with people that are living.
But I believe what happened was they wouldn't accept the.
They who? I'm sorry, they who?
The appellate, the clerk of the appellate division made us actually amend the captions of all of our papers after the substitution had been done, and we filed it that way. It was our understanding that's because it was allowed for us to do that. Otherwise, we still would have been stayed. The stay was lifted in an order.
It's not amended.
Okay, so you follow the clerk's advice. You got to look at the CPLR. Sorry.
So I think we have to adjourn the, I think we have to adjourn it.
I don't know what.
I don't know what we have to do, but
I don't know.
None of them seem to have an answer.
This is a.
We would have to go back to stayed until because the stay wouldn't then be lifted, I would think, Your Honor. We would have to go back to being stayed, and then we would have to get a, what?
My head is
But do
spinning
you
right
agree
about
that-
now.
This court to get the stay lifted, we need to.
Do you agree that there's no substitution in the record before us?
I believe on the record before you, you are correct. I believe it was only in Supreme Court Bronx County. But then we were made to amend, the clerk made us amend our captions on our,
Yeah,
on our brief.
someone should have thought at that point, let's supplement the record right away.
Yeah, exactly.
Yeah. Or
Yeah.
supplement the record.
Yeah.
Simple enough.
5 lawyers.
So we need to stay everything. You need to move to substitute the record to add these.
Well, you know, the thing about, I don't know what's going to happen once you guys substitute with all these arguments in front of us. I don't know if you guys afterwards go back and think, you know what, here's another argument that I want. You know, in terms of if we stay there, I don't think that makes a good. I don't want to handcuff the attorneys of what they want to do because of what happens here.
I think we have to adjourn. We'd have to adjourn.
Adjourn?
Okay.
We adjourn it and then
Withdraw it.
make some motion to get the correct.
Yeah, so
Court level.
you withdraw?
Withdraw,
Withdraw it? Yeah, okay, yeah, I guess you'd have to withdraw it, right?
Withdraw
the
do it
appeal?
again because you're ready to go. If you're truth, you're worthy. You're ready to go. You can just put it right back on, right? If you withdraw the appeal.
You know what, why don't you go to,
The notice of issue for argument.
can you go to the clerk's office? Go to the clerk's office and ask those individuals who are wiser than we are in terms of procedure as to exactly what occurred.
And why don't the five of you then figure out how to deal with this? Why don't the five of you then figure out how to deal
I
with
think
this so we can
she's
reach the
kind of,
merits?
you know, referencing a joke. How many attorneys does it take to screw in a light bulb?
Actually, I wasn't.
Five of you guys? Okay, but seriously, if you could just go to the clerk's office and figure out how we're going to proceed, and I will do what they tell us.
Your Honor, I will go to the clerk's office right now with the other.
With the other
counsel.
four,
I'll bring
yeah.
The others along and get this figured out.
Oh, we are? Who are we? Who?
American Bridge.
Oh, I don't know. I don't know that we got a.
I guess American Bridge didn't show
Oh
up.
man,
You still get instructions from the clerk as to what to do.
Okay.
You might
no,
want to call them.
Yeah, they may call them. Okay, thank you.
Thank you, Your Honor.
All right.
Okay,
Apologize
appreciate
for
it.
taking up your time.
I see my time is up. I have nothing
I will
further.
follow whatever they say in terms of the record, okay? Matter, oh wait, I'm sorry. Yes, matter of Carmen F. Who is that assigned to?
That was Ellen.
Oh, see, that's why.
When?
Ellen, you wanted to set it up. You wanted to adjourn it.
Has this ever happened before?
No, of course not, of course.
I didn't want to adjourn it. I just wanted them all to go away.
All right.
Okay,
You got the
we're
right
ready-
party.
we're ready for you
They
now.
got the right
Good
party.
afternoon,
We got
guys.
all the parties.
You got all
in
the
here.
parties here? All
I'm
right.
much simpler than the last case. The first issue, Richard Hirschfeld for appellant, by the way. The first issue I'd like to address is the deviation between the petition and the court's findings and whether or not that was permissible and the findings could be upheld. As I'm sure the court is aware, there is a significant deviation between the allegations of the petition and the testimony of the complainant. There's a deviation in what actually happened, when it actually happened, how it actually happened, and all of that.
Was a motion made to conform the pleadings to the proof, which is
No,
very common in Article 10 proceedings?
There was not a motion made, but in
And when the proof was entered that was not consistent with the allegations, were there objections appropriately made?
objections to the testimony, only in summation, where counsel indicated.
That's not a place for objections.
I-
So no timely objections were made to the evidence which you now claim was not consistent with the pleadings?
No, but in Valerie P., which is cited in the brief, this court reached this issue in the interest of justice, and we would suggest that for the reasons I'm about to state in weight of evidence argument, this is a case where interest of justice should be exercised as well. In terms of the weight of evidence, as I indicated, there were significant deviations between what the petition said, what the statement was made to CAC, and what she testified to at the hearing. The event was 3 years before reporting. There are deviations in the way the complainant reported how it happened in terms of what time of year it was, which the aunt completely refuted, where she went after it happened, and the 3 years in and of itself. You've got a single witness case here, which he said, she said, but you've got no medical.
There were no objections to her testimony
There
on
were
that
no
basis?
objections to her testimony, but we're talking, in summation, I believe certainly weight of evidence is preserved because he said the petition should be dismissed because of all these factors. So it's definitely preserved in terms of evaluating whether the proof met weight of the evidence. You've got, like I said, the deviations, the lack of, the court relied on Melissa P. This is not Melissa P. In Melissa P., you had those deviations, but you also had corroborating evidence. There is zero corroborating evidence here. You've got no medical, you've got no photographs,
Well, the court found that the child was detailed in her description of the actions by the father, specific and detailed. The court also found that the child was credible, and no evidence was presented as a reason or a motive for the child to fabricate sexual abuse allegations.
But at the end of the day, Judge, it's still a one-witness case where you've got no supporting evidence and you've got...
You find that in sexual abuse cases, it's normally one witness because people tend not to abuse others or abuse children like in a courtroom or in front of witnesses. So you tend that these cases are one witness. So you would have to be able to assess the credibility of that one witness, and it seems as if this is what the court did.
It did, Your Honor, but in glossing over the deviations, the court found that these were minor deviations covered under Melissa P., and we submit that...
How old was the child in this case?
I'm sorry?
How old was the child in this case?
I believe 10 years old.
10 years of age. So the court assesses the credibility of a 10-year-old in terms of his or her ability to testify, to reflect, to act, to give specifics as to what occurred?
Well, 10 years old at the time of the event, not at the time of the testimony.
At the time of the testimony.
I'm not sure of the time. I think maybe 17?
Same thing, though, right? We have to assess the credibility of the 17-year-old given the circumstances.
Understood, but where you've got the aunt coming in saying, this never happened, appellant was not at my house at the same time that she was, and the one time she did stay over, it was springtime, we were wearing shorts, it wasn't winter vacation. You've got a complete discrepancy between the two people, combined with the single witness and the discrepancies in her own narrative.
Well, the father did admit that there had been an overnight visit, right?
An overnight visit by the complainant, but not in appellant's...
He had an overnight visit with
that
child.
Was, right, that was the bathroom incident, though. That's
right.
not the primary incident, though, occurred at the aunt's house.
Okay, thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court. Amy McCampbell on behalf of the Administration for Children's Services, ACS. Your Honors, this Court should affirm the family court's finding of abuse and neglect against the father. It was well supported by the child's graphic testimony of the incestuous rape that she suffered at the age
Was there a substantial discrepancy between the testimony that was admitted and the allegations in the petition?
Absolutely not, Your Honor. And I noticed that the appellant doesn't provide any examples today, but his primary argument that he made in the brief was a mischaracterization of the petition. He mischaracterized it as alleging that the father anally penetrated his daughter. It didn't say that at all. It said that the father bent her over the bed and she felt his private areas in her butt. And then she testified in court, credibly, that the father raped her from behind. And she explained that it was vaginal penetration. She also explained why there might have been a discrepancy in the phrasing, because she said when she was interviewed at the Child Advocacy Center, she didn't use the word vagina or butt, she used private parts. She said she was nervous. She was 12 years old at the time of the interview. She was 9 years old at the time of the alleged rape. These are the differences in phrasing that are minor and peripheral. There's no discrepancy. There's no inconsistency. And in any event, to the extent that there even is a difference in phrasing, this is not any basis to discredit the child's consistent, credible testimony. The family court explained why it found her testimony to be credible. It was based on the family court's assessment of her demeanor, the detail and specificity of her account, the fact that she did not embellish, and the fact that the father has never so much as even suggested a reason why she might fabricate these allegations. And she stayed consistent under cross-examination. Her testimony was corroborated in key respects by the father's own witnesses. For example, the child testified that her father raped her in the sleeper sofa in her aunt's living room. Her aunt testified that she has a sleeper sofa in the living room. The child testified that the bathroom incident was interrupted when the ex-girlfriend knocked on the door of the apartment. The ex-girlfriend admitted that she didn't have keys to the father's apartment, which would explain why she would have knocked on the door. So there was corroboration in the other witnesses' testimony, witnesses that the father himself presented. So there was ample basis for the family court to credit that testimony. And at the end of the...
Also, and the family court judge went, in her 8-page decision, went through each witness's testimony, correct?
Yes, Your Honor. It was a very detailed decision and explained, again, the basis for why the family court credited the child's testimony and credited certain aspects of the other witness's testimony and didn't credit other aspects. And the family court had ample basis to discredit the father's testimony. For example, the father had suggested that it would have been difficult for him to have committed this sexual assault because of his medical problems. But then he admitted that he fathered 3 children since having his colostomy surgery. So his arguments were disingenuous at best. And his own testimony was contradicted in key respects by that of his own witnesses. For example, he said that he never saw his daughter in 2019. His ex-girlfriend said that they saw each other several times that year. So there was ample basis for the family court's credibility determinations. And at the end of the day, what the father can't get around is that the family court's credibility determinations are entitled to significant deference. The family court saw the witnesses, heard their testimony, and observed their demeanor. And he's presented no basis to overrule the court's determinations. So we ask this court to affirm.
Thank you.
Thank you.
Just briefly, Your Honors, in terms of corroboration, the fact that the aunt had a sleeper sofa in her living room is hardly the basis to corroborate these serious allegations against appellant. And the court is aware of what's in the record. There's no medical, no photographs, no prompt outcry. A 3-year-old accusation, which is very difficult to defend against, conflicting narratives, and an aunt who says this never happened. And based on all that, we would submit that any finding is against the weight of the evidence. Thank you.
Thank you. Thank you both. Newelt versus 33072 Owners Corp.
Good afternoon, Your Honors. Michael Rogers on behalf of Appellate Plaintiff. What we have with our appeal is we're asking that the lower court decision be reversed. The lower court, in its decision, and it was a motion to dismissed our portions of our complaint for grounds that were not even expressed in the motion by the defendant. Moreover, what the court down below did is they had interpreted the House Rule 4 in an unreasonable and unworkable way. It had taken
the House Rule.
Go ahead.
You're going to ask the same thing I was going to ask.
Go ahead.
You do it better.
I don't see anything unreasonable about the motion court's interpretation of Rule 4. Frankly, it's exactly how I would have interpreted it, either as a lawyer or as a tenant.
Last sentence, in the event of disagreement, and I think we can concede that there was a disagreement, among shareholders, the board of directors shall decide.
And that's what we're looking for here. But if I may just answer Her Honor's question, this is completely different. What had happened was that the court said that
Wait, aren't you the appellant?
Pardon me?
Aren't you the appellant?
We're the appellant.
So you said that's exactly what we're looking for.
No, what we're
You're looking for the board.
What we wanted from below, based upon the activities that occurred here, is we wanted that when there was a determination or when there was a disagreement between my client and the shareholder, then a decision has to be made by the board, by the co-op, as to whether what is being designated as an additional furnishing or decor.
Oh.
And we believe it should have went to.
There's nothing in Rule 4 that says that the co-op. There's nothing in Rule 4 that says that the co-op can only decide whether one shareholder's decorations are better or the others. All that it says is that the co-op will decide, and that's what it did. Is it decided on something else?
No, it's sort of like as if there's a deadlock. The court should have decided. It didn't decide. What it did is it ultimately was first trying to force my client to negotiate. It made no determination as of the time with respect to the existing.
But ultimately, it said, this is what you're going to put in your hallway, right? And why wasn't that consistent with Rule 4?
Because it's not. Because what it was done on a retaliatory basis. It was done in a way that was showing favoritism for the other side. What had happened here.
How does it show favoritism to the other side? It says we're not going to accept yours. We're not going to accept the appellants. We're not going to accept the respondents. We're going to come up with our own design.
Because the one critical point here is that what was in place, other than what was being proposed by the other shareholder of Penthouse South, what was in place had already been accepted. What was in place was already part.
By the prior tenant.
By the prior tenant,
But there's
exactly.
nothing in Rule 4 that binds the subsequent tenant to what the prior tenant agreed to.
House Rule 4 simply says that when the shareholders cannot agree, the board of directors will decide. It doesn't state how they should decide. It doesn't say how they should go about making that decision. It simply says that they're going to decide. They decided. They rejected both declarations, and they decided we're going to use our own declaration.
No, they didn't. That was what they ultimately came to, but they did not decide at the time when it should have been, when it was first came before the board. The board was given either the furnishings or with respect to the items that were being proposed, it was either we objected, there was
So you're
no
blaming the
consent.
board for giving the two sides an opportunity to work it out amongst themselves rather than them dropping the hammer right away?
Not for the duration in which they were trying to force changes in for my client to accept an alternative that she was objecting to.
So now she doesn't have to accept that because the board has made a determination that they're going to have their own, put forth their own furnishings.
But the portion of what the board should have done under House Rule 4 is they should have made a determination with respect to what was being proposed. Not, if it was not accepted, they could either say, the shareholder may put that there, or the shareholder may
Where
not
does
put
it
that
say,
there.
where,
Not go
what,
through it-
excuse
wait,
me, excuse me, what in Rule 4 limits the co-op to those two choices? Why, if they don't disagree, if they don't agree, why doesn't Rule 4 permit the co-op to do whatever it chooses to solve the problem?
Because what Rule 4 provides, when it's a mechanism for it, is only for it to decide with what is being proposed.
Where does it say that in Rule 4?
It says it in written language where if there's no
Where,
consent,
what is the language in Rule 4 that says that?
is if there's no consent, it says what was just being read.
In the event of disagreement among such shareholders, the board of directors shall decide. It does not state how they decide, what considerations there are, whether they have to accept one over the other, or whether they can put forth their own. And that's what they did.
It is stating here, I disagree, Your Honors, respectfully submit that what it is stating is with respect to the items that are going to be proposed for being decorated, if there is no consent.
Where does it say that?
It says, the building shall be decorated, furnished by the shareholder, or otherwise in a manner without the prior, with the prior consent of the shareholders to those apartments. Such hall shall serve, which hall serves as the means of ingress and egress.
In the event of
the event,
disagreement among such shareholders, the board of directors shall decide.
Shall decide with respect
Your
to those
time is
items.
up. You have time on rebuttal. You can decide then.
Good afternoon, Your Honors. Frederick Sung of Boyd, Richards, Parker, and Colonelli. May it please the court, for the respondent, of course. Your Honors, this is a classic case of a disgruntled tenant who is just displeased with the decorative scheme and wants to
Rule
challenge.
4 basically says the board shall decide. It could either go with proposal A, proposal B, or another proposal that they think that is appropriate. That's it.
That's absolutely correct,
So
Your
in this
Honor.
case, they went with C. They did it
Right.
their own way.
I believe counsel and his client are trying to hang their hat on this language.
Well, yeah, because they don't like the decisions made by the board in terms of the decorations, which they say are cheap, generic schoolhouse fixtures.
I would agree with that, Your Honor. And I just do want to highlight some language that the appellant uses repeatedly throughout her paper, saying that her decorative scheme and decor were rule compliant. As Your Honors had touched on when counsel was up here, decorations in the shared hallways are only rule compliant insofar as the other shareholder across the hallway is in agreement. And the language we submit is very clear that the moment that there is no such agreement, and as Your Honor had alluded to earlier, the board has the power to step in, but rather than, immediately force everyone to live with something.
What happened here is really simple, right? They couldn't agree, so the board came in and said, neither one of you gets what you want. This is what we're going to do.
That's our position, yes, Your Honor. And also, as far as the plaintiff's opportunity to fully litigate this matter, we think it's important to bring light to shine a light on that as well, because the plaintiff wants to argue that, or I should say the appellant, wants to argue that this motion was converted to summary judgment by the lower court improperly. At the outset, our position is that that never happened. There's no indication that that ever happened. This was an appropriate adjudication of a motion to dismiss 3211, and the proper result was had. And the lower court appropriately also noted that once House Rule 4 was correctly decided in our client's favor, there is no purpose to maintaining these claims at law once the contract is in our favor, which was correctly decided. There's no reason to have us, come back and just do another motion for summary judgment on that issue, and wait, another length of time for that decision when the decision is clear. And even if we were to admit, arguendo, which of course we do not, that this motion was converted to summary judgment, a case cited by the appellant is very instructive on this issue. Huggins versus Whitney on page 20 of the plaintiff's brief, which this court decided in 1997, finding that there are 3 situations in which no such notice under 3211C is required. One being that the parties consent. No reasonable person would say the parties consented to turning this to summary judgment. That's fine. But the other 2 factors are strong. One of the other factors being that it's a purely legal issue. This is a pure contract interpretation over one provision of the prop lease. So it's the respondent's position. There's not really a credible dispute on that front. And the other factor being that the parties had a full and fair opportunity to litigate, and that they were aware of the issues and the stakes when it was being litigated in the lower court. On the summary judgment motion, and the record bears this out, both parties are litigating vigorously over the meaning of House Rule 4 and the proper interpretation. The motion was submitted. That's one opportunity. The second opportunity to litigate that issue.
Is there anything stopping these penthouse neighbors from now getting together and deciding, we don't like what the co-op did, so we're going to do what we want, and agreeing?
I suppose, yeah. But to the extent that, based on the plain rule, as long as one shareholder doesn't agree, the board can decide. So I don't think there's any, I think the way the appellant wants to frame this is that it would allow for sort of like the rule of the jungle or something like that.
I think the response is theoretically there is not.
Right,
But-
right. So that's all I have, Your Honors.
Thank you.
We rest on our papers.
Your Honors, with respect to the recent comments, the application in the lower court was not even to address the House rules. It was to address the dismissal of certain elements of the first cause of action for breach of contract, those relating to injunctive relief. The motion itself was a motion to dismiss. It was, by virtue, if you look at the actions of His Honor, it was converted to a motion for summary judgment without any notice. On those grounds alone, the decision should be reversed. And again, with taking one more bite at the apple with respect to House Rule 4, the decision by the co-op was, and it really requires some discovery, is what was the motivation behind the co-op in finally coming and making a determination that they did do, where they changed what the interior
that kind of invitation, you would set the entire co-op industry in this town on its head, what you just said.
No,
co-ops, they have the business judgment rule to protect them.
Yeah, and the business judgment rule and the cases that I believe we've cited demonstrate that rule, if it is not in good faith or if it is based upon some sort of favoritism or discriminatory or bias, that it's not applicable.
Thank you.
Thank you.
Wong v. Wong, Justice Gesmer is recused. Very nice. You shook hands beforehand. Hopefully you will shake hands after the argument as well.
I'm sure we will, Your Honor. Good afternoon, Your Honor. May it please the court. This matter turns on whether respondent made proper disclosure of his assets under his myriad net worth statements such that appellant could make an informed decision to accept an equitable distribution of marital assets. If respondent omitted, this court must reverse. At the outset, The record is indisputable that
Wait a minute, your client, unless I have my dates wrong, after this judgment and divorce went through, in 2015 commenced an action or commenced a proceeding in Taiwan, arguing that there were assets in Taiwan that should have been put in the equitable distribution pot?
38 days later, yes, Your Honor.
38 days later. Why not go back to Supreme Court and say, hey, wait a second, there's fraud or whatever, misrepresentation and all that. Why go to Taiwan? And then not get a ruling that was in her favor either at the end.
Well, you're actually...
Did not mention the stipulation in time.
Right.
Well, I think that ruling actually was in her favor.
When it said that the property, the real properties they're not marital property, they don't belong in there?
The quote is, all of respondents' real estate located in Taiwan were not included in respondents' marital property for distribution, and Taiwan punted back to New York. They dismissed on international comity grounds. I mean, I've read that Taiwan order a dozen times at least, Your Honor. Take my word for it. To answer your question, I wasn't the counsel below, that's why. I mean, I took the case as it came to me, but nevertheless, the record is clear. Aside from the 10 properties, there were 11 securities in the amount of $647,000 that were not disclosed, a money market fund in the amount of $1.064 million that was not disclosed, and other cash assets and transactions in the amount of $290,000 that were not disclosed. That's $2 million, by my count, of non-disclosure. That is incredibly significant. Now, the cross motion dismissing the case was not summary judgment, it was dismissal. Nevertheless, Judge Hagler granted it on inadmissible hearsay. Respondent and his sister both testified that about what his deceased parents did or did not do. Moreover, under the same motion, respondent directly said, at the time I submitted the 2008 net worth statement, I was not aware that these stocks were registered in my name. I was never aware of these transactions. I had no idea of the relevant transactions. That was in, 2021? Respondent claimed that his father passed away in 1999. His mother passed away in 2012. Why were these items not included in his 2014 net worth statement? We submit, Judge Hagler misread the evidence. This was dismissal. On dismissal, we're entitled to the benefit of every favorable inference. There were clearly factual questions here. It is abundantly clear that respondent did not meet their burden sufficient to attain dismissal. And unless the panel has any other questions, I'll yield the rest of my time. Okay?
Thank you.
Your show.
May it please the court, Gregory Getz for respondent Ricky Wong. Judge Hagler dismissed the case on the grounds that there was absolutely no fraud in this record that induced Mrs. Wong to execute that agreement.
Well, she claims she was not aware of the bank accounts in Taiwan, right?
Yeah,
Is that correct?
Yeah, but they're all on his financial statements. I put this all in. I'd be here forever reciting where those are, but in my brief, the Jade Mountain account, the Union Bank account, first I went to her counsel, I said, when I saw the complaint, and I said, these are all on the financial statements. And so they found some more at the summary judgment motion, and I said, these are on the financial statement as well. In fact, the $1 million state capital bond fund account in Taiwan, and I've cited it in the record, she said over there, yes, he disclosed these in the U.S.
And also the real property. The real property.
I wanted to read that from the record.
She conceded, I think, at some point that, yeah, those are her separate properties.
522 of the record. Undisputed issues, number 4, all of defendants' real estate located in Taiwan will not be marital property for the purpose of equitable distribution. I mean, it couldn't be clearer. And frankly, below in her affidavit, paragraph 8, she said, I know that all his Taiwan real estate was premarital. And when you look below, once that was in, she gave up on all of that stuff with the real estate. And frankly, her complaint says those parcels were valueless. Mr. Wong put in evidence, his affidavit, he said those were remnant scraps, they're worthless. We're talking nothing here with respect to the real estate. She concedes they're worthless. She put in no proof below. He said that they have no value. She spent 4 years in Taiwan, could have discovered all this, and I had plenty of opportunity to prove that that had value. It has no value. All of these alleged non-disclosures are right on the financial statement. All of the 4 departments here are in accord. If you disclose the nature and identity of the asset, you don't have to give exacting valuations. Particularly here, where in this agreement, she said, I've had a full opportunity to conduct disclosure, 7 years in the matrimonial case, 4 years in Taiwan, and 3 years here. And we have no evidence of anything, just these roving allegations, this constantly moving target. Every time you point something out, they go, well, what about this? And Judge Hagler spent we argued this orally, 3 hours. And he waded through this, and he did a very good job on that decision. And I want to say there can't be any reliance here, even if there were non-disclosures. It's in her Taiwan papers. Her lawyer over there put in evidence when we said, wait, there's an agreement. She didn't mention this agreement. She didn't attack it. We said, we have an agreement in the US. You've got to vacate that. And they said, no, we're not going to vacate that because that would have cut off the $300,000 that he was obligated to pay her. And so she waited 3 years, got that, saw that case was...
She ratified the agreement.
She ratified it. And, you know, it boggles my mind. On page 12 of their brief, they say, we are not challenging the validity of the stipulation here. That's a quote. I don't know what we're doing here. Honestly, it's a textbook case of ratification, and it's a textbook case of reliance. And frankly, the law doesn't look kindly on these, and particularly the First Department, Goldman, Kosovic v. Goldman. We look with disdain on these post-judgment claims of concealment of assets. And these were all right on the financial statement. And I didn't get into this below, but he was deposed for 2 days on those financial statements by a very reputable lawyer here, and they found nothing. And that's when he got out of the case. She went and tried the case, tried to put these in evidence. I put the referee's report in, and it was all rejected. They go, these aren't marital assets. What are you doing? And so she said, as part of the negotiation, the execution of the agreement, she goes, I'm not settling any of these assets in Taiwan. I don't care if they're non-marital. I'll get my claims going over there. Her lawyers verified that in Taiwan. And so how could you possibly be relying on anything that happened here? In fact, her last brief, she said, I wanted to wrap it up real quick and get over here. It says that. So we got no non-disclosure as a matter of law. We've got no reliance as a matter of law, and we've got ratification as a matter of law. And these are uncontested documents, primarily his financial statements and her pleadings and briefs in the Taiwan proceeding. I think Judge Hagler got it right.
Thank you.
Thank you, Your Honors.
So, counsel, I'm assuming that there's no dispute that she received the financial statements, right? She had all the financial statements, right?
Well, which financial statements is the question? Now I'm about to blow a hole in that. The financial statements in the record that were submitted in support of our summary judgment motion are entirely devoid of all the accounts, stocks, securities, mutual funds, real estate, everything else that he claims. I'm going to show you exactly where, and I want Your Honors to write this down. Record page 594. That was the financial statements submitted in support of their cross motion to dismiss. The date of the certification on that, remember, this was commenced in 2008. The matter settled in 2015. The date is August 4th, 2020. It was non-contemporaneous documents submitted. When there's a dispute about what the documents are, what the documents say, the validity of the documents themselves, they do not meet the dismissal standard because they are not irrefutable.
What about ratification by her actions? She's been accepting and receiving benefits under the agreement, right?
I don't know how anyone can make that ratification argument when she's been in constant litigation since 2008. She went before Judge Gessmer, who's recused. She went right to Taiwan because apparently she didn't understand letters rogatory. And then within a month of the Taiwan matter settling, she commences let's say the third action, but the second action before New York Supreme. She's been in constant litigation, constant strife. All she wants is her share of the marital assets, and even discovery into what those marital assets very well may have been. Respondent, I believe, paid her $138,000 in equitable distribution and walked away with $2 million free and clear. I respectfully submit the order of Judge Hagler should be reversed.
Thank you.
Thank you, Your Honor.
Oh, they shook hands.
They shook hands? Excellent.
Oh, nice.
Yeah, exactly. 5 Star versus Silverite Construction. Everybody's going to shake hands now. This is going to be the new thing.
No, but I'm going to shake his hands afterwards.
Oh, okay.
Good afternoon, judges. My name is Michael McDermott. It's my honor to represent 5 Star Electric Company in this appeal. In connection with this appeal, there's really two, in my opinion, two major items. The first point is that in Justice Reed's decision, we contend that he overlooked two components of our first cause of action, which is the breach of contract. For the subcontract balance of approximately $303,000 and the extra work claims of approximately $684,000, which was a component of our first cause of action. In the decision granting the motion to dismiss, Justice Reed did not address either of those each of those components of the first cause of action. The way we read that decision is that they were dismissed because Justice Reed dismissed the first cause of action. There was, as we argued in our appeal, there was no analysis in connection with either of those components of the first cause of action. The delay claim, which was a large portion of the motion to dismiss, was focused on that, and there's no part of that decision relating to the delay that would fit into the dismissal of either the subcontract balance, which is a standard claim in any construction case, as well as the extra work claims.
Why? Let's get to the heart of from what I think is the problem here, is that there are no damages for delay, right? I mean, that's the big part. I mean, what we're talking about, what you're arguing about is like...
Yes, but the no damage...
That's your roadblock here, because you don't even get to your thing about, I'm owed money if you don't get past this. Although Justice Freed did give you a carve-out because there was some sort of payment that was made, and he says, I don't know how much of that payment that was made to the defendant that you may be entitled to.
Of course.
But the whole... you got a wall here, no damages for delay,
Well,
and that's based on another... same language in Judge Cohen's decision, dealing with the MTA. I know you got the school construction authority, but he's got the MTA. It's the
same. But the no damage for delay is not. If you would apply it to every, there would be no.
No, but your compensation is the extended time that you're supposed to give. That's based on what I read. Your compensation for the reverse or the opposite of no damage for delay, that means no money, but you'll get more time to finish your project. That's what that says.
Well, it's our position that the Justice Cohen's decision does not fit within our case, because there's the case law for collateral estoppel is that there are different elements of proof and the different evidence that's required to apply the no damage for delay to our case. And the Justice Cohen decision was made after all discovery was done and in connection with motion for summary judgment. Our case was a motion to dismiss.
So give me one reason why you think that collateral estoppel doesn't apply. Just you ticked off. You're saying there has to be. You gave the buzzwords. So just point to one thing.
If you were to take every construction case that exists, I do construction litigation for a living. That's what I do.
Right.
And if every entity that claimed a delay, they would be forever barred from any kind of claim.
As long as it's in the contract, right? I mean, if the phrase is there, yeah, they'd be barred.
Yes, the phrase is there. I'm not going to dispute it. But there are exceptions to the Covino Cerveta claim. There are circumstances under which the Covina
Willfulness,
does
you
not
know,
apply. Exactly.
you know, bad faith and
Yes.
blah, blah.
And but we pled those in our complaint. And we, and as the case law says, when you plead your construction case, you do not have to anticipate every defense that may be raised, so you don't have to have a 100-page complaint. As long as you allege and state with the verified complaint, which was our complaint, but the factual allegations that fit within the exceptions to the Covenants Severa, then you survive, in our opinion, you survive a motion to
I'm glad you
dismiss.
mentioned that. How can you argue bad faith when the other side actually went before the SCA and tried to get more money for you and try to get money for the delay? How could you argue bad faith? We're putting aside the waiver issue for the moment, but them going to the SCA and say, hey, you know, guys, you know, there's a lot, you owe us more money and you owe my subs more money. So doesn't that tear apart the
I don't believe so. In fact, I do believe that actually fits within our claim because they're saying that there's a bar. You cannot get past no damage for delay. And then on the other hand, they're trying to negotiate our delay. So either
that goes to your exceptions argument. The exception to the bar is that you got to show bad faith, willfulness, and some other nefarious conduct. And these guys are walking for you.
I believe the bad faith and nefarious conduct goes within the scheduling and the progress of the project, not necessarily for the processing of claims.
Thank you. You have time on rebuttal.
Thank you, Judge.
Your Honors, may it please the Court, Craig Parker, Cohen Seglius, Powers, Greenholm, and Furman, on behalf of the defendant respondents. With respect to the first point that counsel raised, we agree that the decision of Justice Reed doesn't really address the subcontract balance portion of their claim, nor the extra work portion of their claim. And the reason for that is because they didn't ask for it and they didn't argue for it. That said, we would concede that the subcontract balances, which represents earned payment or earned funds that are owed to them for work that was performed under their base contract, we would concede that that amount, which is I think around $300,000 or so, would be owed to them, albeit we don't agree with the amount that they are claiming because we believe we have back charges and offsets. So that portion of it, we would concede we could modify that point.
It's really not a fight. There's not a fight about that. The big fight is delay,
The big fight
for
is
delay.
correct. The delay and also the extra work claim we believe fits within the delay because they don't argue otherwise. So that said, the argument that somehow it's bad faith for a general contractor to take its subcontractors' claims, package them with their own and with other subcontractors, submit it up to the owner, try to negotiate on everybody's behalf, get something from the owner, and then have a piece of that is earmarked for a particular subcontractor. And then when the subcontractor is not happy with the amount that was collected on their behalf, that subcontractor, to be able to get around what you said was the wall, which is the no damage for delay clause that's in the subcontract, and hold the general contractor liable for the balance of the claim that was sought, would throw the entire general contractor, subcontractor relationship on its head. There would be no reason.
And by doing that, there's no waiver. You don't read that as a waiver, right?
There is no waiver, and there's a no waiver clause in the contract that says just
the exception doesn't even carve out a waiver.
It does not carve out a waiver. And
so it all goes down to no good deed goes unpunished.
That's
Go
exactly.
ahead and do something, and this is what you get.
That's exactly it. And in the future, no general contractor would ever take that step and pass through a claim because they would be subjecting themselves to liability.
If we were to accept the
despite a
appellant's
no damage for
argument,
delay clause that they negotiated and they bargained for.
like I said before, we turned the entire construction industry on its head.
It would disrupt the entire industry. So so I don't see how there's bad faith there. As far as the collateral estoppel issue, I think the appellant continues.
Well, he said bad faith in the sense you're scheduling. You messed them up with the scheduling. You messed them up with in terms of prioritizing projects. That was all delays, and that was all based on bad faith. That was based on one single affidavit.
And that's a potential exception under Carino to the no damage for delay.
Right.
However, Justice Reed found that they didn't establish any factual basis to establish any of the exceptions, including bad faith. And what you would have is, you would have a general contractor submitting a claim to an owner, not collecting enough that the subcontractor would be happy with, and the subcontractor would then turn around and make a bad faith claim against the general contractor, and that would not be sustainable. Just with respect to the collateral estoppel argument, the law is not that the facts have to be the same from case to case, but that the issues have to be the same. The fact that it was the MTA here and the SCA here doesn't change the fact that it's the same parties, it's the same fact pattern, it's the same language, the same subcontract. The fact that they might be seeking 200 days here and 300 days here isn't a distinguishable fact that says, okay, now these two cases are different. And one of the cases that we had cited, and then they cite in a gotcha type of way, is this Lindgren case. But that case involved two different sets of evidence and two different sets of proofs, so that the case there, collateral estoppel didn't apply because there was a distinction. Here you have sophisticated contractors that repeatedly do work together, and without collateral estoppel, when they use the same subcontract form and they face the same issues, every construction project has issues, they have delays, they have whatnot. Doesn't mean that every delay is uncontemplated or contemplated, doesn't mean that every issue fits within an exception to the no damage for delay. And you would, without the collateral estoppel, you would have suit after suit after suit after suit on the very same issue, on the very same facts, on the very same subcontract language from case to case to case. And that would also be
Well, that may be the case, but you have Carino Savetta there.
Correct.
So even if you don't have collateral estoppel, you still have the parameters there.
correct. That's the thing that's missing here, is that Silverite still has its right to enforce its no damage for delay claim.
Thank you.
Thank you.
Very briefly, Judge. No, but the point is that, yes, there are exceptions, and there's a reason why there are exceptions to give contractors like Five Star, it's day in court. As we argued to Justice Reed, it says, I'm entitled to discovery on these claims, okay? The same way that there was discovery in the Justice Cohen's case, and that was as...
I got a question. When you say you're entitled to discovery, but you would have that information yourself with respect to the delays, and if they were willful or in bad faith. I mean, your guy that you had the affidavit with, he's the point person, so he would have all that information. Well, on this date, they delayed it by doing this, and we know that was a load of, that wasn't really the reason. It was because they didn't want us to finish on time. I mean, he's there. He's the point person. So when you're saying you want discovery, your discovery is in your hands. It
is in our own hands, but it's our allegations as to what we say are the delays. But the discovery to which we're entitled is the information that we derive from Silverite as to the cause of these delays. The fact is that we had did overhead and that we had delays in connection with the TCO that was issued. Temporary certificate of occupancy that was issued to Silverite in order for us to, but this is the discovery that every construction case is going to have. At the end of the day, we believe that by dismissing the case on a motion to dismiss, as opposed to a motion of summary judgment, denies our opportunity to have a day in court, and that's what we're asking for.
Thank you.
Thank you very much.
Lowman v. Consolidated Edison, Justice Gesmer is recused.
Good afternoon, Your Honors. May it please the Court. Kenneth Gorman for the plaintiff appellant respondent. The dispositive facts of this case are not in dispute. Con Edison admits that it didn't conduct one single visual inspection of the airplane cable in over 55 years since it was installed in 1960. Michael Berrios, Con Edison's lead elevator mechanic, testified at pages 430 to 433 that inspecting the cable and counterweight required a visual inspection to make sure that it wasn't frayed, broken, or loose. However, he admits at page 434 that this was not possible because the cable was in a tube. However, the Pell Manual warns against this. It states at page 703 of the record that elevated doors had to be inspected at least every 6 months and warned that any protective covers that block a visual inspection had to be removed.
I'm sorry, counsel, who do you represent?
Oh, the plaintiff appellant, respondent. On the case law cited at page 5 of the plaintiff's reply brief, and the commentary to the PGI state that where an object is capable of deteriorating over time and concealed from public view, the owner has a duty to conduct reasonable inspections. And under those circumstances, Weller versus College of Senecas and Watson versus City of New York, which we discussed in our reply brief, a duty to conduct reasonable inspections makes the issue of constructive notice irrelevant. I'd like to refer the court to this court's decision in Conklin versus 500.
So, counsel, in terms of your common law negligence claim to, what about that? Wasn't there, what would be the basis to grant summary judgment on that? Aren't there contradictory expert affidavits as to your common law negligence claim?
I don't think so. And the only thing that Mr. Schloss says, Ronald Schloss, Con Ed's expert, is that this door was not a Appellate gate. It wasn't an Appellate gate, but it doesn't. He doesn't really connect how that makes any difference with regard to Con Edison's liability. While the drawings from 1960 don't reveal the gate's manufacturer, Michael Berrios.
Didn't your expert rely on that premise that it was a Appellate gate?
I'm sorry. Can you say that again?
Didn't your expert rely and say that it was a Appellate gate?
It was a Appellate gate, yes. And Michael Berrios, Con Edison's lead elevator mechanic, he testified that this was a Appellate gate and that he ordered Appellate parts for and that he had a Appellate manual for. His testimony wasn't equivocal. And Schloss's conclusions that Con Edison's inspection procedures and methods were reasonable, it didn't take Mr. Berrios' testimony into consideration that a visual inspection was the only way to conduct an inspection of this cable, which was blocked.
So Berrios says he checked the guide rails, the guide shoes to make sure there's no binding, and he said the counterweight was not visible, but he said he uses the troubleshooting manual.
Well, I'm sorry, can you?
He said he used the troubleshooting manual.
That's correct. He uses the troubleshooting manual, which warns against covering cables like this because they have to be visually inspected. A visual inspection was what had to be done to make sure that the integrity of the cable was intact. It wasn't done. Con Ed admits this. And the case law is clear. Where an object is capable of deteriorating, it must be periodically inspected. Con Edison admits that it never did it. Its liability is clear on this record. Court has no other questions.
In your res ipsa?
Res ipsa? The facts speak for itself.
No, I know what res ipsa means. I mean, what is your argument as to res ipsa?
This object, this was strictly in Con Edison's exclusive control. The plaintiff had nothing to do with this accident. She was not at fault. The only thing she did was walk out of the elevator. This is a classic.
Don't you have to find that there was some type of malfunction on for the elevator doors?
The malfunction was the cable. It broke. The cable snapped in half. And the only way to prevent that from happening was to conduct periodic, reasonable inspections, which were never done in half a century.
Thank you.
Thank you.
May it please the court, my name is Dan Ratner. I represent Con Edison on this appeal. I think it's really important to understand how all this played out in the motion practice below. Plaintiff moved for summary judgment on these issues by submitting an affidavit by Mr. Karajat in which he said that Con Edison was negligent in only one respect, by swapping out a chain that keeps this door moving up and down for an airplane cable. That was their entire theory upon which they sought summary judgment. Con Edison opposed the motion with an affidavit by Mr. Schloss in which he said, guess what? That never happened. It was always an airplane cable. And by the way, this company called Appellate, which supplied some of the parts, didn't actually supply that particular part in this situation. It was a company called Houghton that actually installed the elevator. Now, there are two doors. There's the outer door, and then there's this screen door that goes up and down, which is what fell on the plaintiff. So that's what they did. They moved for summary judgment on a very, very narrow theory. We disproved that theory, and then we cross-moved for summary judgment and said, guess what? An airplane cable is strong enough to withstand, to hold the weight, and the procedures that were in place for inspecting this were adequate. In that, you check the cable to see that there's no fraying, that it's properly lubricated, and you do it on a monthly basis. That's good enough. So we opposed it, we cross-moved for summary judgment. So then, Mr. Karajat now submits a new affidavit in which he says, oh, I wasn't aware it was swapped out. But he's the one who called the guy from Pele who told him that it was.
Well, he said it was his assumption, right?
Yeah, he made
that
this.
Pele had supplied it.
He made an incorrect assumption. So now he submits a new affidavit in which he attempts to sort of rebut some of the opinions by our expert, but he never really says anything about the inspections, except at the end, very end of his affidavit, where he says, there were several methods of, this is at page 759 of the record, there were several methods available to Con Ed. The cable could have been inspected for wear and tear, wear and connectivity by simply pulling it up and out of the channel. They could have made a section of the channel removable to facilitate inspection, which they did after the accident. That's not really what happened.
That's why I was asking, wasn't there some dispute between Karajat and, if that's how you pronounce his name, and Barrios?
And in fact, Mr. Barrios later put in another affidavit. He's the gentleman who did the work and said, no, you can't pull it all the way out. It's sort of housed in this tube and it's not visible, but we pull it all up and down. We see most of it. That's a factual dispute, Your Honor. That's all it is. Factual dispute. Now, just one other thing. Throughout the motion practice below, never once did this issue of AFSCME, these standards, these industrial standards, come up. Dr. Karajat never cited any of them. Never came up. Wasn't even pleaded.
I think they concede that. They concede.
Well, but here we are, and all of Mr. Gorman's argument really is based on these industrial standards on appeal for the first time, and not only that, he's saying it's negligence per se. So unpleaded, unpreserved, and now it's negligence per se. We get summary judgment. That's not how it works. That's not how this played out at all below, at all. So that's my argument with respect to the plaintiff. Now, if I can for 1 second, there is no reason to overturn the portion of the order that granted Con Edison summary judgment on the breach of contract theory for failing to procure the proper insurance. Why? Why? Because specifically, Nelson agreed to obtain insurance that covers Con Edison for its own potential negligence. But what they ended up doing was naming Con Ed an additional insured on a policy which was only for Nelson's.
Yeah, they had to do that
negligence.
because the indemnification clause had them indemnifying Con Ed for its own negligence, and you needed to have that component of the insurance. Otherwise, that standing alone would violate the general obligations.
Exactly right. Now, the plaintiff, though, is...
And it also didn't list the Yonkers location. It only listed Irving.
That's right. They didn't even get to the right location.
Correct.
So Nelson's going to say that, well, you know, that's the insurer's problem. So why are you blaming it on us? Well, we can't go after the insurer because the policy speaks for itself. It didn't cover it. So what are we supposed to do? Well, we're pointing fingers at the entity that was supposed to obtain the right insurance, and there's no reason to disturb that aspect of this order.
Thank you.
Thank you, Your Honor.
Nelson.
Good afternoon. May it please the court. Sim Shapiro from the law firm of Strykowski, Drachman, and Shapiro on behalf of the third-party defendant, Nelson. As the court alluded to, in fact, one cannot be indemnified for their own negligence. And by all accounts, regardless of which expert you believe, this is obviously a mechanical issue. There's no dispute here, none, that Con Edison is responsible. In fact, I think the building manager said it best on page 322.
Yeah, but you know, putting that all aside, they're now looking for coverage, right? So at the end, how do you get around the argument that you didn't get the right insurance? And the argument saying you're going to blame the insurance carrier, well, that's for you to go sue the insurance carrier, not for them, because right, you're the ones who purchased the policy.
I respectfully disagree. In fact, I just heard my honored colleague say, well, what are we supposed to do? And there's nothing they can do. Of course, that's not correct.
How do they go after Hanover?
An additional insured can always sue an insurance policy, and I've done it many times. I've been in this court many
Why
times.
are you making them do the work? They don't want to do the work. They want to make you do the work.
Well, not only that, but plaintiff worked for you, right? She worked for Nelson.
Plaintiff was my client's employee. That
Right.
I love that argument. Go, look, you guys go take care of it.
Yeah, I mean, but again, you were supposed to supply the insurance. You were supposed to name Con Ed as an additional insured, and you know, the policy does not reflect Con Ed. It doesn't reflect the location in Yonkers, and it talks about Con Ed's own negligence, I think, or something like that.
So here's
It did not talk about Con Ed.
So a couple of things. First of all, by all accounts, let's take a step back. By all accounts, my client purchased the coverage with explicit reference to Con Edison as an additional insured.
No
so
question.
we can start with that.
Yeah.
So they purchased the coverage. There's really no case law where a party can obtain summary judgment when in fact the coverage was purchased. Here the situation is, okay, the insurance carrier is taking
because the coverage is almost a nullity because it doesn't cover Con Ed because they're not, again, listed as an additional insured.
I like that argument, though.
Yeah.
That's a good argument.
They are listed as additional insured, and I'll add, if you read the declination letter from the insurance carrier, they said actually they would consider that. In fact, if you look on page, I believe it's 967 of the record, in fact, in their letter, in their declination of coverage, they talk about, notwithstanding the fact they're not a schedule, Hanover considers the claim for additional insured coverage under this endorsement.
Right, and I'm sure Hanover would be very pleased to indemnify, to cover Con Ed under these circumstances.
The issue is not whether they'll be pleased or not. The issue is whether they considered it. And the issue here is if, in fact, the coverage was purchased and the insurance carrier, a non-party, takes the position that, in fact, it's not covered or it's outside the scope of the coverage, the appropriate, and I've cited case law in my brief, the appropriate remedy is for the additional insured to sue the insurance carrier. My client paid premiums, extra premiums, to have a Con Edison named as additional insured. It's there. That there's no dispute about. So if the issue is, look, the
So, you know, if I were to buy
your
your argument, if I were to accept your argument, that means then going forward, that anybody can just buy an insurance, name someone as an additional insured, without considering anything else, but as long as they're an additional insured, and I've satisfied my obligation, irrespective of whether or not my
To add to that, why would you not have some responsibility to ensure, excuse the pun, that the additional insured is, that the policy is correct in terms of additional insured, et cetera?
I don't think anybody's going so far as to say it applies in all circumstances. I am saying what we're talking here is we're talking about the scope of the extent of it. And I'll add one other thing, which is I'm not Hanover's counsel here, so I'm not going to take that position. But the idea that, look, the coverage applies to anything so long as it happens in that building, because everybody agrees this is outside the scope of my client's work. My client does not repair that elevator.
I thought the declination also said that,
elevator.
I saw also it says that the 30th Worth Street was not the location of the covered operation.
Right.
I thought that's what the declination also said.
They went further than that and said that they'll consider it. And if you read the declaration of coverage letter on page 967, it does say that.
Well, whose the onus is it on? Is it the additional insured or the guy who actually purchased the policy?
The onus on to do what?
To make and tell the insurance carrier, I think you got it wrong.
I think the bottom line is it hasn't been determined yet because there's been no decision. So if in fact this court is saying, look, It's your job to sue the insurance carrier on their behalf as an additional insured. That still hasn't been adjudicated. And for that reason, summary judgment would be inappropriate. The issue here is summary judgment. And it's difficult for my client to be in a position to say, look, we purchased the coverage, and we may be of the belief that it does apply, but Hanover, at least at the present time, is taking the position, but there's been no final adjudication. The issue here is summary judgment. So I would respectfully submit that even if this court is correct.
What's the issue of fact?
The issue of fact is whether it is or is outside the scope of the coverage. And I would.
It would seem that based upon the declaration, it is outside the scope of the coverage.
Again, that's the position the carrier is taking, but there's a second issue of fact. The second issue of fact is what I just mentioned, which is, look, is the coverage meant to apply to anything? When we're talking about a mechanical defect, or that's the allegation anyway, that is by all accounts outside the scope of my client's work. If that's the case, it doesn't apply to everything in the building, doesn't apply every single instance that happens at that building. There are times where the coverage that was purchased shouldn't apply because
The contract between Con Ed and Nelson required Nelson to procure commercial general liability insurance, naming Con Ed as an additional insured.
And it did. The question is, should that coverage, the second question I would say, does that coverage extend to areas that are way outside the contract? Nobody says that contract applies to repairing mechanical or maintaining mechanical. Con Ed's witnesses were all explicit in saying, in fact, if you look at page 322 of the record, they asked the building manager, is that something inside the scope of the contract? The answer was absolutely not. That's way outside the scope of the contract. So to say, you're not only supposed to buy insurance coverage for the work you're doing, you're supposed to purchase insurance coverage for the work you're not doing. Nobody says it should go that far, and additional insured provision should never go that far to apply to anything, even though it's outside the scope of the agreement. There's nothing in this contract about mechanical. There's nothing in this contract about maintenance of the elevator.
There is an indemnification clause that says you're going to insure Con Ed for all of Con Ed's negligence, okay? So if I buy your argument, then that is violative of general obligations law. So that what you're saying is that I'm not responsible to buy insurance coverage, that's going to cover it for. You got that indemnification clause, which needs that sort of puts the parameters of what your obligations are in terms of insurance coverage.
But it still has to be within the scope of the contract. If Con Ed is
how do you want to read the contract that says that you got to have to indemnify Con Ed for its negligence?
But not negligence outside this. If Con Ed get involved in a motor vehicle accident, that's not within the scope of my contract. So I think there's a point where it goes too far. And that we're talking about mechanical.
Well, I mean, it's a janitorial contract, right?
Correct. It's a janitorial cleaning contract. They've been very clear. Every single witness says maintenance and repairs are outside the scope of my client's contract. They're involved in cleaning and mopping and things like that. The insurance coverage should not go outside the scope of the contract to the point of work that it was never hired to do.
It seems as if you should have put that in the contract.
I think it stands on its own by saying by it's implicit in the agreement that it shouldn't apply to things that are not in the agreement in the first place.
Okay, thank you.
When the plaintiff moved for summary judgment, he moved for summary judgment on two grounds. Number one, using the wrong, not using the chain, and number two, for failing to inspect the cable. At pages 723, the plaintiff argued in support of its motion for summary judgment that...
Aren't you the plaintiff?
Yes.
Oh, okay.
Yeah, I'm a plaintiff. It's a long day.
I was like, why is he referring to the plaintiff? I thought you were the plaintiff. I was like, please, this is number 20-something.
Yes, I mean...
My head, come on.
The plaintiff is not raising any new issues on appeal, contrary to what my adversary is arguing. The Pell Manual states at page 628 of the record that it must be inspected every 6 months. And just to be clear, Con Edison's violations of ASME A17-1, it's due to its failure to conduct...
But I thought you conceded, I thought the plaintiff conceded that you were not raising any arguments as to that.
That's, well, no. Not raising any arguments with regard, not raising any new arguments, but plaintiff...
That you had not raised any arguments at all concerning that. You did not allege a violation.
Yeah, we didn't allege a violation, but but failing...
And you didn't plead such a violation.
That's correct. let me just move on with regard to one more issue that my adversary argued. Although a party can't meet its burden in reply, there's an exception to this rule, and I want to point that out, and I want to be very clear on this. The exception is that when evidence is submitted in response to an argument raised for the first time in opposition papers, it is proper, and you can meet your burden, and the cases are legion. Kelsall versus Diamond, Kelsall Diamond versus Stuart Lerner from this court, 286, Appellate Division, 2nd, 586. Central Mortgage versus Johnson, 150, 83D, 661, 2017, First Department and the Second Department case, both clearly stating that if you raise an argument in response to an opposition, to your adversary's opposition, it is properly before the court. And
thank you. Thank you all. Jesus, Mary Joseph. People versus Jesus Ayala.
Good afternoon, Your Honors, and may it please the Court, Rebecca Martin for Appellant Jesus Ayala. Your Honors, the upward departure to a level 3, which is the highest possible level, was unwarranted based on the totality of the circumstances here. Mr. Ayala was a solid 2 on points. That's even before you take into account that he shouldn't have been assessed 10 points for inappropriate housing. And that 2, that moderate risk, was the appropriate assessment here. That's what the board recommended twice over. And the only aggravating factor that the court below relied on to grant an upward departure was the fact that he had these concurrent forcible touching cases. However, while a concurrent offense may be the basis for an upward departure, that's only if they're indicative of that the defendant poses an increased risk to public safety.
What were the prior acts for which he was?
Those forcible touching, the concurrent forcible touchings, they were all subway touching cases. I believe all of them involved.
And so the current one was also a subway touching?
Yes, the current one was 2 different subway touchings that there was.
And so what was your argument again?
So the argument
that the court should not have looked at the fact that he was currently engaged in that behavior?
No, Your Honor. The argument is simply that a level 2 is appropriate, even given the fact that he has these concurrent forcible touching cases.
So don't the concurrent forcible touching show, or is some indication that he continues in this behavior?
They might indicate a higher risk of reoffense. These are all concurrent.
Because he's already reoffended, right?
All of these offenses happened before any arrest. There was an arrest and then he was.
I'm sorry. So you're saying that the court should have disregarded those?
No, Your Honor. I'm not saying that the court should have disregarded those offenses. Rather, I'm saying the very first thing the commentary talks about is the fact that when you're looking at a risk level, you're looking at both risk of reoffense and the harm caused if the defendant were to reoffend. And
so aren't we beyond risk since he has already engaged in this behavior again?
I would like to emphasize it wasn't again. It was. I mean, he was arrested and then linked to these prior offenses. So he hadn't reoffended since being arrested, spending time incarcerated, doing treatment. All of that happened after any of the offenses in question here.
What about the inappropriate living situation?
So the inappropriate living situation, he was assessed points there.
10 points, okay.
Sorry, he was assessed points there because on the basis that it might be difficult to locate, the logic being that at the time of the hearing he was uncertain of where he was going to live. However, the case law is very clear that mere uncertainty is not enough to assess points in that category. And actually, because Mr. Ayala, regardless of where he was on points, was going to be subject to SARA, and on the basis of DOC's policy, he would not be let out of DOC's supervision without an address. The court below didn't seem to fully understand that there's the case that they relied on, Almany, was about someone who'd been homeless in the past. When he was being released, was going to be homeless again.
Was this the case? Because I don't want to confuse the cases. Yeah. Where his daughter, he gave his daughter's address or something, but
So
she didn't really have permanent housing, and then the prior, or she wasn't sure about the housing, and then his other family members didn't want him to stay.
It was
with
unclear whether or not he would, with his daughter, I don't think it was true that she was unsure, but it was unclear whether or not that would be approved by probation, whether or not she was okay with it. But because our point is that even if he couldn't find anyone to live with that would be approved by probation, he would still not be let out of Doc's custody without at least a bed for him in a shelter. That's the operation of Doc's policy. Like, he could not have no address. They will keep people past their release date. And so that is our point, is this is a case like all of the other cases that the Second and Third Department have seen where, yes, there's uncertainty whether he'd be with his daughter or in this bed in a shelter, but it's not the case that he might be released without any address. Like, Docs just wouldn't let him go. That is how that policy works.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Sheila O'Shea, and I represent the respondent on this appeal. With respect to the points assessed under Factor 15, the issue is moot. The Court reached a total score of 95. Therefore, had the judge erred with respect to the 10 points, the defendant would have been assessed 85 points, which still landed him as a level 2 offender. And the defendant's suggestion that the Court was less careful, I think, is not borne out by the record. In fact, the Court was extremely careful in rendering her decision. She waited several weeks to render the decision. She issued a 16-page decision, and more importantly, she repeatedly referred to, read from the guidelines, and cited the Court of Appeals case in Alamany. So I think it's to suggest that she exercised a lack of care is not borne out by the record. And in any event, couple things on Factor 15. The defendant had given conflicting statements about where he had lived in the past. On the one hand, he said...
Didn't he provide 3 different resident addresses?
He did, yes.
2 in Connecticut and 1
2 in Connecticut. And in fact, in Connecticut, what's particularly troubling is that there was a fugitive warrant whereby the authorities were unable to locate him. So the community ties, the so-called community ties, did not enable his detection. Again, he made conflicting statements. On the one hand, he said, I'd like to live in Queens, and then subsequently told Docs, I'm not sure where I'm going to live. And really, there was nothing, he acknowledged that his 5 daughters were mad at him because of the behavior he'd engaged in and the nature of his convictions. Again, there was really nothing, he really didn't have any options. And on the Sauer point, I think to take defendant's argument to its extreme, anytime an offender was subject to SARA, he or she can never be assessed points under Factor 15.
Right, I was thinking the same thing, that becomes academic. Why assess points for the inability to find housing?
And furthermore, I think the court didn't say very much about her decision to reject the defendant's SARA argument, but I think one would be right to be skeptical of what Docs was going to do in the future without some concrete information as to what shelter or what facility in which the defendant would be placed. I think it was too speculative, notwithstanding Docs' obligation under the statute. That's not to say that Docs necessarily would have fulfilled its statutory obligation. And there's really no precedent on this, so I think the judge was right to reject that argument. On the upward departure, I think the judge properly relied, again, citing the guidelines. She explained that because she had not assessed points under Factors 9 or 10, she was entitled to take into account the 3 misdemeanor offenses for the non-registrable offenses. The judge, in her 15 years on the bench, knew that these types of crimes had a high rate of, these types of offenders had a high rate of recidivism. And I think she was uniquely, as a woman, I think she was uniquely positioned to assess the emotional harm that this behavior inflicted on the victims. Now, I think the guidelines even bore, she noted that in the guidelines, excuse me for a minute, she cited the footnote, the guidelines at page 2, note 2, where the board distinguishes between public lewdness or someone exposing himself and hands-on contact with the victim. And that's exactly what we had in all 3 of those other cases. In each instance, the defendant used his elbow to touch the defendant's breast or the defendant's thigh, while in 2 instances appearing to be masturbating. So I think it's right to say that the emotional harm, particularly because one of these victims was 13 years old. And even though that circumstance was already taken into account on the scoring of the RAI, I'm not sure that it adequately accounted for the trauma that a girl that young would experience as a result of being touched by a strange 60-year-old man on the subway.
Thank you.
So, thank you.
First of all, I'd like to clarify, I didn't mean to imply that the judge below wasn't careful. I just think, though, she was careful in her reasoning. I disagree with where she ultimately went. On the harm, I would just like to quote from the guidelines that a sex offender whose modus operandi is to rub himself against a woman in a crowded subway car, that is their example of someone who, even if they have a relatively high risk of reoffense, the risk of the harm that they will cause is less grave. And the risk assessment is supposed to be a balance between risk of reoffense and risk of harm. I don't mean to downplay the harm that is caused, but when we're looking at the range of sex offenses, which go from, the opposite example is like a child molester, I think also like a violent rape, when we're thinking about what is the highest risk of harm, what Mr. Ayala did here and his, the modus operandi that may have been indicated, that falls into that less grave category, which is why we never asked for a downward departure for level 1. Kind of looking at everything together, the repeated pattern, but also the level of harm, a level 2 is what was appropriate. And again, I'll emphasize that is what the board recommended twice. On factor 15, I just want to briefly say the board did not recommend those points. And my argument would not be that anyone who is subject to SARA necessarily couldn't get points there, but rather if you look at Alberico, what that case was about was someone who'd been homeless in the past. When he was homeless in the past, he had chosen not to live in a shelter, but instead to live on the street and had no contacts in the community. If you had someone who was like that, even if they might be guaranteed a bed, you might still say, okay, but in the past they've decided not to stay in a shelter. But that's different from a case like this, where Mr. Ayala had never been homeless, never lived on the streets, did have community contacts, and would have an address because of DOC's policy, which DOC's always keeps people, I mean, that is just, I've cited articles that talk about this policy, they don't let people go. So I would like to, that really flies in the face of reality to say that he would have been let out without a bed, at the very least.
Thank you.
Thank you.
People v. Silvestri, Rosas.
Good evening. May it please the court, my name is Daria Schieferstein, and I am pro bono counsel from Kramer, Levin, Naftalis, and Frankel, along with the Legal Aid Society for Mr. Rosas. This is a case about a 62-year-old father of 4 and longtime business owner who has already served nearly 4 years of his probation term in an exemplary manner. Mr. Rosas' sentence to a probation term of 5 years is excessive in light of his lack of criminal record, stable life conditions, and contributions to his community.
Also, doesn't the waiver of right to appeal foreclose the argument?
So I argue that the waiver of appeal is invalid. The Court of Appeals has held that appeal waivers are enforceable only so long as the totality of circumstances reveal that the defendant understood the nature of the appellate rights being waived.
The Court of Appeals has sustained waivers that are far less comprehensive than this one here.
I would argue that the totality of the evidence and the record makes it clear that my client did not understand what he was waiving away.
You say that in your papers. You say that it's unlikely that he understood, but there's nothing. You don't follow up by why you say it's unlikely. You say he received only a 4th grade education during his formative years in Mexico, did not speak English, and had minimal experience or familiarity with the legal system or appeal waivers. By the same token, I think he was 50-something years of age?
59.
59 years of age. He was a business owner. Although I believe you state that the business was in his own community, there's still papers that have to be filled out, forms that have to be submitted. So I'm not understanding how you could say that it was likely that he did not understand the waiver.
So there's two. So for instance, when the court, there's evidence in the record that he did not comprehend what was being spoken to him.
He had
while
an
he was in
interpreter.
court.
He did have an interpreter.
I understand,
The language
but
that he spoke, right?
He did have an interpreter, yes, but we don't have we don't have a record of what was translated. And for instance, when the court asked him,
We have an official interpreter. So
sorry?
the oath that they take and the understanding is that they are going to translate correctly.
okay, for instance, when the court asked Mr. Rosas if anyone had forced or threatened him to sign the waiver of indictment, he responded yes. And the court then asked him if he had understood the question, to which he responded no. And,
And there was follow-up, wasn't there? Wasn't there follow-up at that point?
I mean, he then responded yes after he was asked whether or not he understood the question. However, I think that points to the fact that he was confused to some degree as to what was being asked of him.
That also suggests that the court was following up whenever, in a situation where where the court believed that he was not understanding what he was saying.
I'm sorry,
Where-
the court,
that the
yes,
court followed up when it perceived that the defendant wasn't sure of what the question was.
Yeah, there's also the written waiver that was presented to him in only English when he does not speak English, and there's no evidence in the record that it was ever translated for him into Spanish. And, further during the plea proceedings, the court explained the consequences of signing the waiver of indictment and then had him sign both the waiver of indictment and waiver of appeal before ever going into anything about the waiver of appeal. Again, my client doesn't speak English. I think that is a large barrier. He, yes, operates a business, but in his community where he speaks Spanish, he's not a sophisticated defendant. And I would say, additionally,
So let me just say that if I were to agree with you that the waiver is invalid, how does the recent enactment over a year now, the less is more statute, affect your client? He's on probation. He's got a year. By all accounts, based on your representation, he's living a good life. I mean, he's doing okay. He's staying within the guardrails. Doesn't the law itself offer credits for that?
I mean, I would say that, so he has 1 year left of probation. He is currently in extremely poor health. He has had to sell his business recently. And so the remaining year is still.
You didn't answer my question. I mean, I don't know if you did the analysis as to how does the statute itself offer some sort of accommodations for that type of situation where he's done nothing wrong and he's got all these issues. I mean, it's a very holistic statute now. I mean, it's no longer the draconian, you've sneezed the wrong way, you go right back in.
Mm-hmm. I haven't done that analysis. I apologize. Okay, thank you.
May it please the court. I'm Amir Kedmati for the respondent, the people of the state of New York. Good afternoon, Your Honors. Your Honors, defendant was facing 3.5 to 15 years of incarceration. He only received a probation term for 5 years. All the mitigating factors my adversary cites.
Was there anything in the record as to who the subject of the search warrant was?
The subsequent search warrant?
Who was the subject? Was there anything in the record as to who the subject of the search warrant was? This was based upon a search warrant to his apartment, and then the gun and the 98 bullets were found in the safe. So my question was there anything telling us the subject of the search warrant?
Your Honor, there was not a lot of information about the search warrant itself in the record. All I have here is that on May 29, 2019 at 9:30 p.m., pursuant to a valid search warrant issued by Honorable Judge Beth Beller of the Bronx County Police and...
Right, I read that. Yeah. So he was sentenced to 5 years probation. What would be well, first of all, let's go to the waiver. Is anything improper about the waiver? Anything that would lead us to believe that he did not understand the waiver, either the oral allocution or the written waiver?
Absolutely not, Your Honor. The defendant waived his right to appeal the excessiveness of his sentence, and it was the oral colloquy was near perfect. Justice Pittsburgh's colloquy was, it really covered all the bases. It checked all the boxes enunciated in Court of Appeals decision in Thomas as well as in Lopez. Even absent the written waiver, I believe the oral colloquy in this case was sufficient. And furthermore, defendant's age and circumstances evince a knowing waiver, as he cites in his paper. He was a businessman. He was not an unsophisticated individual. Furthermore, this was not his first time.
What do you say about the prosecution's argument that the waiver was in English, He's a Spanish speaker, and there's no evidence that it was translated.
Your Honor, there was evidence that defendant was aware of the content of the waiver. The court asked the defendant, in fact, is this your signature on the bottom of the waiver of the right to appeal above the line that it says defendant? Yes. And did you sign this waiver in the presence of your attorney here in open court? Yes. And it was only then that the court found the waiver to be valid. So that waiver forecloses the defendant's claims here, but really the offer here was a great offer. He was definitely going to serve some jail time if it wasn't for all the factors that they put before the lower court. And we don't believe that this case merits a further reduction of his sentence. And I just wanted to add, he will be released on December 4th, 2024. And if I may, Your Honor, you alluded to the Less is More Act. I don't believe it applies to this defendant because he was not incarcerated at all. And the Less is More Act applies to defendants who are on post-release supervision. And I don't want to get into the information. I had a brief conversation with the probation officer. I don't want to discuss that, but my understanding is that he's going to be released on December 8th, 2024. And insofar as he's been in compliance with the terms of probation, we believe that then that means that probation is working. And for the safety of community, it's a good idea for him to continue to be on probation for another year. And lastly, I'll just say that while the defendant said that he found the gun, he never provided any explanation about what happened to the 98 bullets that were discovered inside the safe in his bedroom.
Thank you.
Or how they were discovered. Thank you, Your Honors.
Thank you. I would like to respond to the point about the leniency of the sentence. Respondent's argument that the sentence is lenient is largely predicated on the notion that Mr. Rosas would have been convicted of the top charge, which was criminal possession of a weapon in the second degree. This is legally impossible because to be found guilty of this, he would have had, the prosecution would have had to prove the firearm was loaded. And further, there's a carve-out in Section 3 for guns found in the place of business or a home. So the fact that he could have potentially faced 15 years is legally impossible. Further,
So rather, on the criminal possession of a firearm, it's 1 1/3 to 4 that he faced.
I'm sorry, I didn't.
On what he did plead guilty to,
Yes.
the maximum would have been 1 1/3 to 4.
Yeah, yes, correct. He could, I'm not saying he was not facing potentially any time in prison. I'm just saying that the upper charge of 15 years is not applicable here. But I do want to point out that, there have been several cases in this court from 2020 where defendants have engaged in far more serious conduct and been given the same 5-year probation term as Mr. Rosas. So for instance, in People v. Collins, the defendant was sentenced to 5 years probation after pleading guilty to both criminal possession of a weapon in the third degree and criminal possession of the firearm. And there the defendant had the firearm in his car. And even more to the point, in People v. Anonymous, the defendant was also sentenced to a term of 5 years with a minor fine and 15 days of community service following conviction of criminal possession of a firearm, unlawfully dealing with a child in the first degree, endangering the welfare of that child, unlawful possession of marijuana, and unlawful possession of ammunition, and still received 5 years probation. And just to finish, my client, the possibility of him reoffending, I think, is extremely low. He is elderly. How
old is he?
He's about to be 63. I'm sorry, I didn't.
No, it's okay. I recognize he's of an advanced
He is not a young man.
Watch how you say that.
Yeah, he's of an advanced age. He's quite all right.
He's not talking to me.
I'm old.
He is middle-aged.
Okay, the 3 people at least here. That,
Yeah,
in that
exactly. But that's okay.
Um,
We won't hold it against you. But thank you very much. And thank
you.
you for taking this on pro bono and your firm as well. Thank you very much. Last but never least, People v. William McNeil. Stop.
Good afternoon, evening. May it please the court. Nicole G. Douglas on behalf of Appellant William McNeil. Mr. McNeil's RAI score should reflect points assessed based on the conduct with which he was charged, with which he accepted responsibility and served time. In a 7-count indictment, Mr. McNeil was charged with...
There is a requirement that in order to assess point, the conduct must be charged or that the witness had to be subject to cross-examination by the defendant.
It is not a requirement, but the high burden of clear and convincing evidence indicates that the evidence that supports the assessed points should be evidence that is sufficiently credible and weighty. And in this case, the
Well, that evidence was used at the co-defendant's trial, which resulted in a full conviction.
where Mr. McNeil's interests were not at stake and at which he was not involved at all. The prosecution itself asserted.
I think that's getting back to your argument that wasn't subject to defendant's cross-examination, which we already established is not a requirement.
It's not a requirement, but when you're looking at what is clear and convincing evidence, and the fact that the conduct was not charged, while it doesn't preclude the consideration of the evidence, it does call into question whether it is unequivocal and sufficiently weighty to meet the high burden. And in this case, it did not. The points that Mr. McNeil were assessed were, as you said, based on testimony and allegations that weren't even in play until months after he had pled guilty, been sentenced, and was serving his time in prison. The case itself, as the prosecution explained at the SORA hearing, involved one complainant, and Mr. McNeil's RAI score should have reflected the allegations that were actually made against him. In addition, even if this court were to find that the points could be assessed, the idea that Mr. McNeil should be scored and adjudicated as the highest level of risk is also inappropriate. At most, he should have been adjudicated a level 2 registrant. At the time that he was arrested, he was living in North Carolina, where he had moved with his family away from New York City and was
Living with his family didn't seem to be a big issue for him since when the incidents at issue occurred, he was living with, I think, his mother and sister, right?
in New York City. Yes, he
Right,
was
but
living
there-
in his
but
childhood
the
home.
fact that he's moved to live with his family doesn't mean that he's not likely to be in the same situation.
It shows that he was on the right track at that point.
It's the same track. He was living with his mother and his sister when this incident occurred in terms of the sexual abuse of the victim, the complainant. And then he moves to another state, also living, it's a hint, right? It's 4 o'clock, 4 a.m. It's 4 a.m. He's got to get out. But the
No,
point
it's
is,
never
I'm not
happened.
sure that the
No,
fact
I've
that
been
he's
there.
living with his family means anything in terms of his risk to offend, the risk of reoffense.
And I understand that, and my point perhaps was inarticulate. It was not so much that the living with his family in North Carolina was relevant. The point was that he was in a new environment where in a new state, away from the elements and
Yes,
the
because North
behavior where he had
Carolina is
grown
much
up.
safer than New York or the Bronx. But the other issue, what about the Tier 2 and Tier 3 violations while he was incarcerated? Do we not look to those as well?
He did have disciplinary violations while he was incarcerated, and he was scored points for that, and those points were not subject to dispute. But there is other mitigation that indicates the lesser risk, aside from what's been discussed already, which is the fact that he also pursued productive programming while he was incarcerated.
One of which he was removed from. Wasn't he removed from one of those programs? I think the alcohol and substance abuse program?
Yes.
He did not have a history of alcohol and substance
But he was
abuse.
removed from the program for disciplinary reasons.
Yes, and as I said, he did incur disciplinary violations, but that was a program that he didn't need because he didn't have alcohol.
Because you don't need the program and you're in the program does not give you the right to be removed for disciplinary reasons. But you can address that on your rebuttal.
Good evening, Your Honors. May it please the Court, Caroline Williamson for the people. The lower court's adjudication of defendant as a risk level 3 offender should be affirmed because there was clear and convincing evidence that he was armed with a dangerous instrument, threatening the victim with a gun. There were 3 or more victims to his scheme, and he had sexual intercourse and engaged in a continuing course of sexual misconduct with the victim. The repeated sworn testimony of the victim is first aspect of the evidence that was clear and convincing. The Court of Appeals in Mingo specified that when testimony is made under oath, that's a significant indication of reliability.
So it can be considered, the sexual intercourse, the rape could be considered as a factor in terms of assessing points?
Yes, the fact when he had sexual intercourse is the way that it is laid out.
I recognize that.
Yeah, but yes, it was a rape, and that is.
But to be clear, he was not charged with that rape, right?
He was not charged with that rape, and we don't have in the record all of the reasoning why the trial ADA did not decide to pursue that charge, but there are a lot of reasons why prosecutors don't pursue all charges available. But that evidence was presented to the grand jury when the grand jury did vote on the charges in the indictment, and he was indicted on 3 counts of sex trafficking, 2 counts of promoting prostitution in the second degree, and 2 counts of promoting prostitution in the first degree. But the evidence in the grand jury and before the in the trial of the co-defendant, which was completely consistent between those 2 instances of sworn testimony, was that he raped her repeatedly over the course of over a year. And that testimony was also corroborated by a witness who said that she saw defendant go into the bathroom and have sex with the victim multiple times. And the defendant also admitted in text messages to the victim that he had sex with her in very graphic fashion. So it really is not at all able to be contested that he had sexual contact with the victim, which is sufficient for the points assessed under factor 2. And he did that multiple times. There's also no reason to credit the argument that the testimony needed to be subject to cross-examination. Testimony doesn't even need to be sworn to in order to clear the threshold for clear and convincing. And it also, the charges need not have been, the court is not limited to only charged conduct. People v. Epstein has made clear that you don't even need to be indicted with conduct for testimony to be credited as clear and convincing evidence. And unless there are further questions, the people request that the points assessment be affirmed.
Thank you.
I'd just like to clarify here that there's no dispute as to whether the testimony, the evidence, sworn, unsworn, could be considered by the court. Mingo decided whether or not evidence was reliable hearsay, and we're not disputing that the evidence was admissible. The dispute is whether it was sufficient. And in this case, there's other information that suggests that the information is not clear and convincing, including the fact that Mr. McNeil was not charged or indicted for much, if not all, of the conduct that made up the excess 95 points that the court assessed based on the prosecution's request. I'd also note that the assertions that the complainant before the grand jury, as well as during co-defendant's trial, testified completely consistently, and that there were multiple instances of sexual contact with Mr. McNeil is inaccurate and doesn't reflect the record. In the grand jury, she testified as to 1 instance of sexual contact with Mr. McNeil, contact that he was not charged for. And at trial, she then testified to other incidents that allegedly had occurred. And that was the first time that the other instances ever came up. And because Mr. McNeil was charged, convicted, and took responsibility for an offense involving 1 complainant, he should be assessed points based on what he was prosecuted for and not what developed months and years later. And so we ask that this court reduce his risk level consistent with those positions.
Thank you. Thank you both.